I want to file a counter, can be taken up next week, my lord.
Without us issuing notice. Why are you being so charitable? We have not even, have you issued notice in this?
No.
Then
First time. It has been listed first time.
without us applying our mind to see that notice is being issued, you are already filing counter.
My lord, I have asked to a caveat, my lord.
Sorry?
I have earlier filed a caveat, my lord.
You are aware, I don't know, you're a practitioner in this court? You're a regular practitioner in this court, sir?
My lord.
Are you not aware that unless suppose we dismiss this case, will you file a counter?
No, my lord.
Such a strange thing, no, sir?
Obliged.
May I please, your lordship? In this writ application, the petitioner challenges the order passed by the Lokayukta without conducting an inquiry and the consequential order of the Tahsildar in raising a demand. Before that, I will take your lordship to the facts. At page 4 of the writ petition, both petitioner and the opposite party number 6 are member of the same family. There is some dispute relating to the landed properties, and for that the opposite parties assaulted to the petitioners, for which a criminal case is pending since 2019. And when the charge sheet was filed, the opposite party number 6 made an representation to the Tahsildar. I had a crosser over a government land and I am making illegal mining. And the Tahsildar forwarded that complaint to the police station, and it has registered a police case by the city case number so and so. And thereafter, since the police case was registered there, he made a representation before the collector regarding this. Since no action was taken, then the OP number 6 filed a WPC PIL number 15425 of 2019 before your lordships. And your lordship, by order dated 18/11/2019 at page 7, I have quoted the order, directed the collector to look into the grievance. Page 8, it is stated then the representation regard has been submitted before the collector Jajpur, opposite part number 2, dated 29/7/2019 as per Annex 5, which according to the petitioner is pending consideration. Accordingly, prayer has been made to direct the said authority to consider and dispose of the petitioner's representation expeditiously. And accordingly, the collector under Annexure 1 at page 24 conducted an inquiry and disposed of the writ application. Your lordship, page 24 of the brief. Going through the representation along with the submission of both parties, it is ascertained that the opposite party number 8 and 9 establish a crosser unit over plot number so and so, khata number so and so, out of acre 33.42 decimal Arua, and utilizing the land since more than 30 years. Further, the Honorable Court have passed status quo order over the land in question, WPC number so and so of 2012. Hence, the Tahsildar Dharmasala is directed to check encroachment apart from the plot number so and so, 50 decimal, under khata number so and so, Mauja Arua against so and so. Rest of the land be evicted, and a report compliance to this court for information. And accordingly, the Tahsildar conducted an inquiry and submitted his report to the collector. Through the inquiry was conducted through the revenue inspector, page 25, madam. Joint inquiry report in connection with so and so, WPC number 15425 of 2019. With reference to your order on the cited subject, we visited the spot of inquiry into the matter relating the plot number 2810 under holding number 779 with an area of 33.42 Kisam Pahado, village Arua. The following observations are found as our field visit. A detailed demarcation has already been made for the encroached area of 50 decimal as per the order of the Honorable High Court by WPC number so and so. This area was re-verified on the field level as per the measurement.
See, the two orders of the Lokayukta are not final orders.
There is, in fact, your lordship, page 46, page 47, there is no inquiry, there is nothing. Page 47, Mr. Saswat Das Tahsildar Dharmasala is present in person pursuant to our order, during interaction,
Where are you reading?
page 47, your lordship.
47.
Order dated 27/9.
During interaction.
During interaction, Tahsildar Dharmasala states that he shall take effective steps for
No,
recovery.
so what happened after this? On 25/10, what happened?
My lord, next the Tahsildar issued Annexure 6 at page 48.
No, all that is fine, sir. That is more than 3-4 months ago. What happened after that?
Only the date has been posted. Nothing has been happened.
No, what is, I mean, some date must be there before the Lokayukta.
Only that the Tahsildar is to take steps.
Sir, unless there is a date of the matter, what is happening?
Before the Lokayukta.
Before the Lokayukta, only the matter
See,
has
on
been
25/10,
deferred.
if you come to page 47, it was adjourned to 25/10.
25/10, thereafter this case has been simply adjourned. No effective order has
Which
been
means
passed.
they're not really proceeding in the matter, sir.
Yes.
So we'll say that these are all tentative orders. Whenever the Lokayukta passes a final order, they'll take into account all that you have said in your objection, including the pendency of the
yes.
matters in the court,
Yes.
everything.
My lord, but without finalization, holding an inquiry without finalization, how the Tahsildar?
We don't know. No. Even Tahsildar, I'm saying you already have filed a petition.
Before the Lokayukta?
No, and also in this court, you can always file applications in those application. I mean, writ petition pending matters. You don't have to multiply writ petitions like this, sir.
No, my lord. This is because I approach this honorable court only because of during the interaction the Tahsildar submitted, I will take steps and immediately issued an order as if the Lokayukta has passed the order. Your lordship, for a moment, page 48.
Yes.
With reference to the letter subject, I am to
So
intimate
once the matters are pending in this court, there's a writ petition already pending.
that
And then
is
there's a
related
criminal
to the
MC
ethics, sir.
pending. There's a criminal MC pending.
Yes,
There are enough proceedings by you already pending in this court.
my lord.
So in those pending proceedings, you can always question this demand and all of that.
Only in respect of Annexure 6, my lord. As has been directed by the Lokayukta.
So
Lokayukta
anyway,
has
the
not
challenge to demand notice can't be before a DB here. It normally will have gone to the single judge. Because you're coming against the Lokayukta, it's come before us.
Yes.
It
is a single judge matter, my lord.
Lokayukta, no final order has been
No,
passed.
fine, but this is the Annexure 6. I am challenging Annexure 6. That is the demand.
You challenge it separately, then in a writ petition, you go to the single judge. If you combine it with Lokayukta, it will come here and we will not entertain it. You decide what you want to do.
All right, I will permit it to withdraw.
Counsel the petitioner seeks leave to withdraw the present petition with liberty to challenge the demand notice dated 21/10/2020 of the issued by the Tahsildar, Annexure 6 in accordance with law in appropriate proceedings. Disposed of is withdrawn with liberty is prayed for. All right.
Supplementary list item number 2.
Just now they have served a copy on me, my lord.
Your Honor, I am on behalf of Mr. Mukesh Agrawal. Kindly pass over this matter.
All right.
Item number 3.
My lord, this is the entry tax matter. Tomorrow is fixed for hearing.
All right. List one.
Item number 4.
Opposite party has filed a counter on 30th March, 30th January 2022, my lord. I have already filed a rejoinder. Let this matter will come any other date, my lord. Counter rejoinder have been filed in the case.
What do they say? When was it served on you?
It is the
You had said it served on you on what April?
142021.
1st April. When was it? What do they say in the reply?
They have
Where
already
is the
filed
reply?
counter, my lord. Department has already filed counter.
Where is Mr. Chimanka?
Yes, ma'am.
What do you say in your counter? When was it served on him?
On 31st March.
31st March they have signed but not dispatched. Dispatched on 142021.
My lord,
Based on whose decision of the Allahabad High Court is very
Annexure 1 and page 9. Page 9 is circular and 2 is the dispatch.
The counter is, when did you file the counter, sir?
They have filed on 30th.
It's not come on record. The counter filed by the department will be brought in record, rejoined for the next date. List on. August.
Item number 5.
Interim order to continue.
There's no interim orders.
Item number 5, sir.
May I please be lodged? Lordships may kindly peruse.
Tushar Kanti Satpathy lacks in other court.
We had not even issued notice, I think, in this. Oh, there is.
No,
okay.
your lordships have directed me to find out when this particular notice was served.
The timestamp was.
Your lordship may kindly peruse order dated 11th of January 2023.
He wanted time to verify the record.
Your lordship may kindly peruse it. So this 148 notice, my lord, was issued on 1/4/2021, my lord. Second page, your lordship would see, my lords. I've just underlined that portion, my lords. 148 notice issued on 1st of April 2021, my lords. And this is for the period 14-15 months.
All right, Mr. Kerr produces a document
This
in
reflects
terms
all,
of which the notice in the present case under section 148 of the Income Tax Act 1961 was actually dispatched or issued on 1st April 2021 paragraph without commenting on the correctness of the above submission at this stage. The court directs notice to issue to the respondents. Mr. Satpathy accepts notice and states that he will file a reply within 8 weeks, rejoinder for the next date. You say no coercive steps shall be taken against the petitioner. No further steps shall be taken.
no coercive steps, your lordship.
All right, no coercive steps shall be taken against the petitioner till the next date.
No.
This also lists on 16th August, right?
16. I'd only pray, my lord.
No, it's okay.
Lord, may I pray, my lord, no courses pursuant to assessment order and penalty proceedings.
No need.
Oh, okay.
All that's understood.
May I please, my lord?
Yes.
This matter, my lords, your lordship may kindly, even though, my lord, this is an order under 74, my lords, I'd only pray, my lord, this entire, my lord, proceeding is vitiated because your lordship may kindly turn to Annexure 7 at page 47, my lords. That's the gist of the DRC 07 minutes. Lordship got it, my lords?
46.
Page 47, my lords.
47.
Where the
Yes.
summary of the entire thing is given.
Right.
Then your lordship may come to the table, my lords.
Yes.
This your lordship would see that this is meant for the assessment year 17-18.
Right.
And your lordship would come to the end of that period in response to the order of the Honorable High Court. The taxpayer appeared on so-and-so date and submitted 26 A's for the financial year 17-18. Then what it does is, as per the 26 A's for the financial year 17-18, the taxpayer has disclosed to have received rupees so-and-so from Executive Engineer Rural Work Division, Bhadrak, so-and-so from Odisha State Disaster Mitigation Authority, and rupees so-and-so from the Rural Works Division, Nimapada. I've added all these three figures, my lord. That comes to a figure of 2,14,24,631. 2,14,24,631, my lords. The lordship may just turn over the page, my lords. And this, my lord, in spite of receipt of this amount, which includes, my lord, a pre-GST payment for the entire year of 17-18. GST came with effect from 1/7 to, as your lordship knows, 2017, my lords. And as a, my lord, to demonstrate before your lordship, my lord, I've only given one of my bills, my lord, which is at page 29, my lords. There were some payments in the VAT period, my lords. As an example, I've given Annexure 4 at page 29. So this, my lord, is 4,66,856, which is also included in 17-18, my lords. And there's a clear-cut, my lord, directive of the commissioner as well as the finance department, my lord. The lordship may kindly turn to page 14, Annexure 1. Clause 2, my lords. Lordship got it?
Yes.
Work executed before 1/7/17, but payments made or to be made after 1/7/2017. Since the work was
all right. Just say notice. He accepts notice on behalf of all the opposite parties. Replies within 8 weeks, return up for the next date. So till the next date, no coercive steps shall be taken against the petitioner pursuant to the order dated 8 July 2022. Bracket Annexure 7. List on 22nd August.
22nd August.
Yes.
Item number 7.
May I please?
Obliged, minister.
The limited grievance before my lord is that they are not supplies the documents to me because the transaction is more than crores as per the CBDT circulars, my lord. I have already sending that they have to provide all the documents. They have not provided document for which I am requesting to provide the document in order to submit my reply. The
So
father of-
you file your replies, with whatever you have to say, you say without documents, I'm not able to file reply, but this is like a provisional reply. I know this is what you all say.
My lord, my
Start
grievance-
interfering at this stage where you still have to file a reply.
my lord, that document is not with me that my father has been died who is look after the
So
matter.
you
of the
say all that.
company, basing on which you are asserting 148, my lord. That is the inbuilt provision as per the decision and as per the CBDT circular. I am sending, my lord. Paragraph 7, they have already stated, in case it is more than 50 lakhs, the department has supposed to supply all the relevant documents.
See, if they don't, it becomes another ground for you to challenge whatever they pass. Why do you come in advance?
So only if document they have supplied, we can give you effective reply. I have lack of documents, so that I have requested the authority to supply the document. So
If
that
they
is my
don't,
limited reply.
you file a reply saying you have not, and therefore I'm not able to either give a full reply.
Sir,
or-
I have already given I have already stated in Annexure 7.
Yes.
I have already stated due to death of my father, I am unable to trace out the
All right.
documents. So kindly supply the documents, enabling me to giving effectively a reply.
All right.
This is my limited.
All this you
response.
take as a ground, sir, when an adverse order is passed. All right. You say the grievance of the petitioner is that in order to effectively file a reply to the notice issued to the petitioner under section 148 capital A bracket small b of the Income Tax Act 1961 bracket Act, the petitioner had asked the department to supply all the documents which form the basis of the said notice. So according to the petitioner, despite repeated requests, those documents have not been supplied to him, and therefore he is unable to file a proper reply to the impugn notice. Full stop. The present petition is for a direction to the department to supply those documents to the petitioner. Paragraph: having heard learned counsel of the parties, the court is of the view that irrespective of the documents being submitted, the petitioner, if has not already done, should file a reply to the notice issued, and the right of the petitioner to assail any adverse order hereafter passed in accordance with law, raising the grounds urged in the present petition at that stage, is reserved. Full stop. With the above clarification, the court declines to interfere at this stage. The petition is disposed of.
Receive appearance memos of Tushar
All
Kanti will be put on record.
My lord, it has become infructuous.
Dismissed as infractions.
But here 9, the present petitioner is one of the villagers. He raised his objection to the public notice for shifting, that is Annexure 3. The villagers all filed the objections by the Annexure 4 before the collector within the stipulated time period fixed in the public notice. Thereafter, objection raised by the existing OPSOF and the school management, that has been taken care into, but the objection filed by the villagers that has been never taken care into. Now, in the meantime, the collector has recommended to the commissioner. The matter is sub judice before the commissioner. So only pray, let commissioner consider our grievance to find out the genuineness of our grievance, whether we have.
The petitioners have apparently objected to the
Public notice at Annexure 3.
Have come up pursuant to the public notice dated 7 September 2022, file their objections to the opening of the off shop, is it?
On shop,
On shop.
shifting of on shop. Open number 5.
Object to the shifting of the on shop license to opposite party number 3.
Opposite party number 5, the on shop license.
On 19 September 2022. Full stop. It is submitted that without considering those objections, the collector already made a recommendation to the Commissioner of Excise for issuance of license. Paragraph: since the matter is pending before the Commissioner,
OP number 2.
bracket OP number 2, the court permits the present petitioners to make their submissions No, furnish a copy of their objections to the commissioner. Not later than 13th February 2023. The commissioner will, after considering those submissions and giving the petitioners a hearing.
Reasonable
Take-
hearing.
That's what I've said. On a date to be informed to them at least 1 week in advance. Come on. Pass a final order in accordance with law.
Oh,
And communicate it to the parties, including the present petitioners, within a week of being taken. The court clarifies it is not expressed anywhere in the matter. The petitioners.
obliged.
Passover.
Much awaited decision. He said only a decision will be given. And much reluctantly,
All right,
the
pass
matter
over.
was argued.
Pass
Was adjourned today.
Yes, pass over.
Yeah.
11, 12 and 13 also in the
Pass
Passover.
over. All right.
14.
14,
Yesterday.
sir, page 6, para, the order of the ITAT is not acceptable for the
No,
following
who's the
reasons.
petitioner? Who's the appellant?
Yes, Milord. The time limit to
No,
complete.
no, 1 minute, sir. Is anyone there for the appellant? You're for the revenue.
I'm from the appellant.
Oh, you're for the appellant in
Yes.
item 15.
No, 14.
14. Acha. All right. (153B).
Yes, Milord.
But this is already covered, no? Yesterday we did this.
Yes, Milord, but there is some mistake.
Same thing, no? Yesterday.
That order may be called because I give this explanation only 1 minute. That page 6, paragraph 5. The time limit to complete the assessment under section 153 of the IT Act is guided by section 153 of the IT Act, which provides that the assessments will be completed within 24 months.
So
From
even if you put 24,
Yes.
here it is completed in November. So even it's beyond 24. So
Even that.
1st April 2014, the clock starts running.
Yes, Milord.
Search is in October 2013.
Yes, Milord.
That financial year ends in 2014, 31st March.
16, Milord.
No, so it has to be 1st April 2016.
Yes,
Assessment was completed on assessment orders 25th November.
yes.
So it's anyway time bar. We've said all this in yesterday's order, in view of the order passed by this court on 31st January 2023 in ITA number 19 of 2021. The present appeal is dismissed. All right.
May I please, Madam? Lord, the IA has appeared before your lordship to dispensing with the
Yeah, all right. Dispensing with is allowed. Yes.
the substantial question of law before your lordship,
Loose sheets.
page 14, my lord. That during the survey proceeding, my lord, they have entered my premises and they found 3 slips, loose slips, some receipts with amount to 19 lakhs, lordship. And they added as a income. Lordship, my substantial question of law is in the 133A proceeding. Statement of the assessee is cannot be treated as evidence. It has no evidential value. That is the judgment of the Supreme Court. Rather, the 132(4), that is on oath. That is that can be treated as evidence. So my admission regarding this receipt of 90 lakhs, which has been admitted as the income, it cannot be treated as evidence. First question of law. Lordship, second question of law is in view of the 44 AD of the Income Tax Act, my lord. The total 19 lakhs as they have shown that is received. It cannot be counted entirely towards income. That is the 2 substantial questions of law before the lordship.
All right. Notice returnable. Mr. Mahapatra accepts notice, the department. List on 24th August.
Lordship 16, 17, 18 may pass over.
All right.
May I please? This is the matter. I have already in the last occasion expressed I am suffering from the tooth pain and I moved to dentist so that I cannot appear on such date. So that it has dismissed by default on and with. Thereafter, every day I am appearing. I have no fascination towards that strike, my lord. I have no facilitation for strike, my lord. I have, after that date, in each date, I am appearing, your lords have passed so many orders after 27. A similar matter has posted on 16th August, my lord, because it is the issue regarding issue of notice, my lord.
No, you didn't appear in the tribunal. Oh, 19. Oh, sorry. Acha. Which year, which day was this? 26th October.
Ma'am.
That's why. 27th October.
Sir, I have no intention not to come because due to this reason I am not come. And thereafter every day I am coming. So I have no fascination about the strike. So after 27th, every day I am coming, my lord. Even strike is going on, whatever may be the reasons. It is your lordship's consideration, my lord.
Not convinced, sir. Normally, you'll have somebody stand in at least to ask for a passover.
My lord, my junior is with me from that date when I moved before the doctor, my lord.
No. What is there to ask your colleague? Somebody standing to your right now also. He can even appear online, sir. All you have to do is switch on a camera, webcam.
My lord, I have already tell the truth, my lord. What has happened, my lord? That's why I can develop anything, my lord. That date, due to this reason, I am not coming.
These old habits have all to change, sir. The bar will not improve otherwise. The bar will not improve.
Sir, I may be excused for this, my lord.
Actually, you're risking your litigants. What right do we have to put our litigants at risk? You may have so many differences.
No.
We have no right to deprive the litigant of his day in court. Absolutely no right. In Delhi High Court, they have a practice. 2 members of the bar will be there in the court. It's courtesy you show the court, sir. And this is the Chief Justice's court. The bar makes arrangement, whatever be the compulsion, there will be lawyers standing in saying in this court, this is and there are some urgent orders. Litigants need urgent orders. And the lawyers will say, no, in this case, there's an urgent order. That proxy lawyer will argue. That is the basic, that's a minimum courtesy you show a court, sir.
Your lordship is very correct.
This is all unknown.
What are the really things I have already presented before my lord?
No, you've not. See, you're not being honest. In your application, you're not being honest, sir. That is why I'm reluctant. You're not telling us the real reason why you did not come that day.
Sir, I tell that I am before the doctor, I could not able to come. Then what else I can say, my lord?
We are not accepting this kind of an explanation.
My lord, I have not any
you honestly say why you didn't come, you apologize, we'll consider. You make an honest, see, with 2 judges sitting here, with there being hybrid hearings here, with you never missing a matter, and even if you have to send a junior, this is what you do. Normal days, this is what you do. You have a large office, sir. You have juniors working for you.
I have only 1 junior.
I see. All right.
With me, my lord.
All right. You are very modest. That's all right. Given your extensive, the number of matters you are filing today itself, how many matters you have in this court?
3 matters.
And you have 1 junior at least. What was so compelling on 27th that you could not even do that? That is why we want you to be honest. We want you to be truthful in your application.
My lord, when I am telling that I am in that situation, then what else I can tell? Sir, your lordship said that I am accepting that strike.
The court is not prepared. The court is not prepared to accept. No, the court is not prepared to accept the explanation offered in the application. Particularly since what happened on 27th October 2022 was an illegal call for a boycott of the court by the Bar Association. Full stop. Unless the lawyer is prepared to come clean on the real reason for avoiding appearing in this court and is able to tender a proper apology, the court is not prepared to consider this application. Full stop. Paragraph to enable the lawyer to do so, adjourned to 16th August. You come on 16th August. No. It's okay. Then I don't have to be dealing with this. Whichever bench will deal with it. That's better for you also, sir. Let them read this order and let them make up their mind.
A big apology, my lord.
Not like this, sir. Sorry. Sir,
It is
we
your
have,
lordship's-
we have also practiced at the bar. We have also practiced at the bar. Not like this.
Sir, next-
We could not think
after
of doing
that
these
date,
things, sir.
every day coming and
We
doing
could
the-
not think of doing these things when we practiced. We have to bring back those standards, sir. We have to bring back those standards to the bar. I'm not a person who's going to be cynical and saying, oh, everything's going down the line and I can't do anything about it. I'm sorry. I will do my bit to bring up the standards of the bar. Whatever little I can do. Sorry. Yes.
Item
The
20.
lordships, I'm appearing on behalf of Mr. S.R. Patnaik for item number 20 and 21.
Yes.
Your lordship, in both the matters, Justice M.S. Raman is concerned.
All right. List before a bench. All right. List before a bench of which Justice Raman is not a member. On. Tenth March. All right.
Great. Item number 22. Sorry, my lord, sir. 22. Item 22, sir.
Yes, sir.
This matter regarding filling up of vacancy of the member Odisha Human Rights Commission.
Yes, what's the?
My lord, meeting has already been held, Honorable Chief Minister and the opposition member. Very soon, that is a letter also from the government.
All right. Mr.
that-
Manti, learned AGA states that very soon
The vacancies will be filled.
vacancy will be filled up. The vacancy of member in the Odisha Human Rights Commission will be filled up. At his request, list on 1st March or 1st March.
Item 23.
May I please, Your Lordship? I'm appearing through VC, Your Lordship.
Yes.
Your Lordship, I may kindly be pardoned by order dated 22nd December. Your Lordship directed for removal of defects.
Yes.
I need a week's time, Your Lordship, to get.
All right. List on 1st March, defects be removed in the meanwhile. All right.
Your Lordship.
Item 24.
24, 25, permit to withdraw, my lord.
Dismiss is withdrawn. All right.
Item number 26.
Item 20. Item 26, Your Lordship, the petitioners are the evicted people who are praying for basic amenities, Your Lordship, like water supply, proper hygiene, Your Lordship. These are evicted people in Balisai, Cuttack, Your Lordship. Your Lordship, I have annexed the photograph, Your Lordships, also. From page 33 to page 37, Your Lordship.
This is CMC area or what?
Your Lordship, CMC area.
Where is Mr. He served on Mr. Nayak?
No, Your Lordship, no.
You serve an advance copy.
Oh.
An advance copy of this petition be served on Mr. Devashish Nayak, learned standing counsel for the CMC, to enable him to take instructions. We'll have it next week, sir.
Yeah, Your Lordship.
List on 7th February.
Deeply oppressed.
Item number 27.
27, 29 also postponed to withdraw, my lord.
All right. Dismissed is withdrawn. All right.
27, 28 and 29.
My lord, all three, my lord.
All right.
Item number 30.
Memos taken on record. Dismissed is withdrawn with liberty to file a petition. All right.
Item number 31.
Entry tax matter, my lord. Tomorrow, fixed to tomorrow, my lord.
Tomorrow.
Copy to be solved, my lord. Yes.
All right.
Item number
Tomorrow you have
30.
to bring out a separate list.
Item 31. Item number 32.
And so item 32, I am a VC, my lords. Pray for 1 extra time to rectify the defects, my lords.
All right. List on 1st March, defects be removed in the meanwhile. All right.
Grateful, my lord.
33.
My lords, 33, the assessment order is challenged on the ground of territorial jurisdiction, lack of territorial jurisdiction, my lord. I have given the notification. My lords, I am registered here at Cuttack, my lords. The assessment was made by the officer at Rourkela, my lord. That is the only ground on which I have challenged this. Order, my lords. My lords, the notification I have annexed at page 18, annexure 3.
What are the instructions? So you don't have it.
Just now we have solved the copy,
Yes.
my lord.
Counsel for the department seeks time for instructions.
Appealable order, my lord. Yes.
Yes, I agree. Applicable, my lord.
Or you want to avail the appeal, sir, then that will be easier.
My lords, territorial jury, unless I am conscious of your lordship's view, since it is jurisdiction, case of jurisdiction, I have.
You are otherwise and in the jurisdiction of?
Cuttack, my lords.
All right. Counsel for the petitioner at the outset states that the petitioner is within the jurisdiction of the additional CT and GST officer in Cuttack, whereas the impugned assessment order has been passed by the officer in Rourkela 2 circle. Then paragraph, counsel for the department wants time for instructions. List on 7th, next week.
Deposit. Deposit, my lord.
Sorry?
Deposit, my lord. Redeposit. Appealable order.
My lord.
No, if the jurisdiction itself is not there, then why send him to all that?
You have to take instruction.
Item 34. I am for the petitioner, my lord. May I please your lordship? My lord, this is a matter under the Odisha Goods and Services Tax Act, my lord. Well, what happened in this case, I purchased the goods, my lord, from one registered taxable person, Sri Pankaj Mittal, my lord, during the period from 1st May 2018 to 31st January 2019, my lord. Now, my lord, I verified from the portal that the selling dealer is existing, and my lord, he is regular in filing the returns. Now, my lord, after the purchases were made, all of a sudden, the respondent number 1 issued a notice that he received information from some other department that selling dealer was non-existent. So I was liable to pay tax, interest and penalty, my lord. Now, kindly see, my lord, the so-called notice. No, there is totally non-application of mine, my lord, on the basis of the information received from
this appellate order is a first appeal, is it?
Yes.
So the same thing. You pay 10%.
10% I have already paid, my lord.
All right. You say notice, he accepts notice, reply within 8 weeks, rejoined of the next date. List on 23rd August.
In appeal, my lord,
You say counsel the petitioner states that he has already paid 10% of the demanded tax during the pendency of the first appeal. To stop in that view of the matter, subject to the petitioner paying a further 20% of the remaining demanded tax within 4 weeks. No coercive steps will be taken against the petitioner during the pendency of the present petition. The IA is disposed of.
Good. Good. Item number 35.
35. It is cancellation of GST registration, my lord.
Standard order.
Standard. It is on central GST. This is.
Yes,
my lord. Just penalty and interest has to be.
Both. All right. Same order. Same order.
State.
All right. Same order.
Item 36.
May it please, my lord.
Yes.
36, 37 and 41, my lords, common issues, my lords, challenging 148A order. I understand, my lords, there is a judgment, that Shiv Metallics judgment has also come, which takes into consideration red chilies. Now, my lords, only on that aspect of red chilies, my lords, if I may just make a submission, my lords. Plus, the red chilies judgment says that, my lords, availability of alternative remedy, my lords, doesn't take away your lordship's power. That,
it doesn't.
That is the only.
No, it doesn't. We didn't say that also in that order.
My lords, so that is my only submission. So, therefore, my lords, my humble submission is your lordships has the power to deal.
No, even in that order, we did not say we do not have the power. We only said that we're not inclined to exercise it. That's all.
Very well, my lords, in that end, my lords.
Yes.
Reliance Shiv Metallics
Where is
case,
that
lordship dealt with, my lord, in Shiv Metallics case.
Yes.
My lord, there is only one order. That is only one copy. I am sorry, my lord.
It's para 4, right. In view of the orders passed by this court on 1st December 2022, in writ petition civil 9191 of 2022, bracket Kailash Kedia versus Income Tax Officer, and the subsequent order dated 10 January 2023, in writ petition civil 36314 of 2022, bracket Shiv Metallics Private Limited, Rourkela versus Principal Commissioner of Income Tax, Sambalpur. The court declines to entertain the present writ petition, but leaves it open to the petitioner to raise all grounds available to the petitioner in accordance with law, including the grounds urged in the present petition at the appropriate stage, as explained by the court in those orders.
Very great.
All three petitions.
Plus 36, 37, and 41. All right. All right. Item 38. 38, Milods.
Yes.
This is, Milods, challenging the reopening of the assessment, Milods, under 148. This is covered by your Lordship's judgment of Anil Raj Tuli.
All right.
Which I'm just...
Yeah, here also 148 AD is
no, Milods,
order
this is
under challenge.
I'm not under 148 AD. Milods, here it is challenging the reopening of the assessment, Milods, on the basis of mere change of opinion.
That is also, that can be raised at the time of Milods.
And Milods, here
appropriate stage.
No, Milods, here your Lordships will see the... May I place the facts of this case?
Yes, yes.
Milods, here, Milods, return was filed for assessment year 2018-19 for an amount of 11.25 lakhs. Now, Milods, thereafter, there was a scrutiny assessment, regular scrutiny assessment, which is at page 21, Milods. We'll see. Page 21, your Lordship will see the reason for which the original assessment was made.
Yes.
The original assessment, Milods, we'll see the reason at page 4, page 22, para 4, Milods. The assessee was engaged in trading of iron and steel products. It has been observed that assessee has claimed substantial amount of expenses of rupees 69.9 crores on account of purchase and debited it in the PL account. Now, Milods, this being basically the purchase is what is being questioned here. Now, Milods, will see sub point number 3. It is observed that this is what the notice was about. It is observed that you have made substantial purchases from multiple such suppliers who are either non-filers or have filed non-business ITR or reflected a substantially lower turnover in ITR as compared to turnover shown in GSTR 1 return. Nonetheless, that is the reason for which the original assessment was made. Nonetheless, we'll see the last para. The assessee has not furnished complete details, documents, information as asked for with above mentioned notice. The assessee has not furnished the reply of such. He has not submitted the ITR of the suppliers from whom he has made purchases of iron and steel products amounting to 69 crores during the year under consideration. In the absence of ITR of such and such of suppliers, it is not possible to verify whether the said parties have disclosed the said amount of transaction in the aforesaid from the aforesaid business in their ITR. Now, Lords, the conclusion at para 5. Page 23.
So they've added 0.4%.
Yes, Milods. But Milods, what has been done? The entire purchase, which they are alleging as bogus, that has undergone assessment. Therefore, Milods, it has been applied with a 0.4% rate. Now, Milods, will see the reason for which this 148 proceedings are initiated. Milods, at page 26, Milods, will see.
No, but here they're zeroing on a particular purchaser. Particular seller.
Yes, Milods. That is what I am pointing out. The entire purchase, Milods, has already undergone assessment.
We don't know that. And we don't know that this particular purchase was part of that.
Yes, yes, Milods. That's your Lordship will see. This your Lordship will see page 26. This is the first 148AB notice. At page 27, Milods will see the annexure. That Messrs. Jai Guru Steel such and such has not filed ITR and involved in providing bogus purchase or sale. SSC has made bogus purchase of 1 crore during the financial year such and such. The SSC has made bogus purchase of 2.4 crores from MV Irons, 1.6 crores from JP Enterprises.
All right, notice, he accepts notice. reply within 8 weeks, rejoined up for the next day. You say the proceedings pursuant to the impugn notice may proceed. The reassessment proceedings pursuant to the impugn notice may continue, but no final order shall be passed till the next date. List on 23rd August.
Very well.
All right.
Great.
All right.
Item number 39.
May I please, Your Lordship? This application has been filed against the appellate order under Annexure 3, my lord. And the attachment of one bank attached on Annexure 4, my lord. I have filed against the demand, I have filed an appeal. The appeal was decided expiry, my lord. And which was not within knowledge of the petitioner, and thereafter the bank has been attached by Annexure 4, my lord.
This is the first appeal.
My lord, no tribunal. First appeal order has been.
That's what it's what you paid 10% at the stage.
Yes, my lord. Page 11, Your Lordship. Page
All right.
11. That is the acknowledgement of the
All right. All right.
appeal authority.
Notice, all right. Notice accepts notice. 8 weeks, reply within 8 weeks, rejoined up for the next date. List on 28th August. Then in the IA, you say, the petitioner points out that the stage of the first appeal, 10% of the tax demanded had already been paid. Stop. He states that now an attachment order has been issued on 18 January 2023. Correct. Subject to the petitioner paying a further 20% of the remaining demanded tax within 4 weeks. The attachment order dated 18 January 2023 shall stand lifted. And no coercive steps, no further coercive steps should be taken against the petitioner during the pendency of the present petition. The IA is disposed of.
Item number 40.
Is no more a license.
Counsel for the none appears for the petitioner. Learned AG informs the court that
Item 40.
Your Lordship, kindly have a glance to page 13, Your Lordship.
he says you're no longer a licensee.
But in the belated state, they will impose a penalty.
If they do something hereafter, then you can always come.
May I pray one thing, Your Lordship? They have not taken any decision on Annexure 4, my lord. For that reason, I pray, my lord, let a direction be given to consider Annexure 4. That is my representation, giving me an opportunity of hearing.
That representation cannot be considered now. If at all any demand notice will be sent to him, he will have liberty to challenge it.
With that observation, may kindly be disposed
that
of.
observation is not required. That is there. You can challenge that at any
All
stage.
right. With the license period having come to an end, the cause of action does not survive. We'll stop. Nevertheless, leaving it open to the petitioner to seek appropriate remedies. If any fresh cause of action arises, the petition is disposed of.
Yes.
All right.
Item number 42.
May I please, Your Lordship? Here, my lord, the petitioner is the Nayak Sarpanch of a Kasipur GP in the district of Raigada, which is a scheduled area, my lord. Lordship knows scheduled area, there is a public notice. Under section 27, it is very mandatory to issue a notice to obtain the consent or an objection by the concerned GP, my lord. In response to the public notice at Annexure 1, my
What's
lord,
happened now?
we have filed our objections along with the resolution passed by the Gram Sabha not to allow. That is pending before the collector. He has not taken any steps. So before
the objections stated to have been filed by the petitioners Annexure 2 series shall be taken note of by the collector Raigada, bracket opposite party number 3, before making any recommendation on the application of opposite party number 5.
Renewal of his license for the next
renewal of his license.
23-24.
Full stop. The decision of the collector be communicated to the petitioners not later than 6th March 2023. No further directions are called for at this stage. The court clarifies it has not expressed any view in the matter.
Obliged.
The petition is dismissed.
Item number 43.
My lord, item 43, I am for the opposite parties. On the last occasion, your lordship directed me to file an affidavit showing the vacancy positions. I'm feeling embarrassed, but my lord, for the last 1 month, I couldn't attend the court because I was had to be in the hospital. Your lordship may grant me 7 days time. Documents I have got, but I have not prepared the affidavit.
Mr. Bimbisar Das, learned counsel, appearing for respondents 1 to 13, seeks and is granted a last opportunity to file the affidavit in terms of the order dated 31st October 2022 on or before 1st March.
So, my lord, intervention petition is there for disposal. I am for the appellant. Another intervention petition is also there. And may also take up that.
Yes, please.
My lord, I am the intervener in this case. I am the senior most, and this petition and the petition are junior to me. So
they all are in similar footing.
So
all are DLRs, all are claiming the regularization, and that is why he has filed a petition for intervention.
All right.
Though he was originally not a party in the writ petition.
What is your IA number?
91.
91. And there's somebody in 144 also. You put down both as 91 and 144 for the reasons stated therein. The applications are allowed without prejudice to the rights and conditions of the parties to the petition. The interveners are permitted to make submissions in the main petition. The applications are disposed of. In the main matter, we have to say list on 17th April. 17th April.
And my lord, may I also submit humbly that the order copy of Annexure 8 that I have filed, that is the previous order where the petitioners present respondents were the parties, and that has already been disposed of. And 2 writ petitions were there. 1 writ petition has come up along with this. My lord, may also note that OJC number 2468 of 99 may also be.
No, they're here. 2468 is here, sir.
Next time.
2468 is here.
My lord.
It's already with us.
That record will be required.
No, it's here with us. It's already here.
Item number 44.
None appears for the appeal.
Item number 45.
These are all UGC matters. And noting that no requisites, already requisites filed on 31st of this month. Last year issued notice.
But requisites not filed, so that's also.
Yes, on 31st January, yesterday notice.
You see, requisites already filed now be used for the service returnable on the next date. This whole batch, is it today?
Yes, ma'am. All these are
none of the matters, any service is complete. In none of the matters, service is complete of notice.
Yes, ma'am. None of them. On other matters, notice has been served. But today's matter.
Nobody's appearing in any of the other matters.
No, ma'am.
No, how is it possible?
This notice was issued 3 days back, madam, on 26th. On 25th, notice was issued.
All right. You say fresh notice returnable. How many matters? I think there's a whole bunch, no?
Yes, ma'am. That is your lordship 46, 45, 46, 47, 48, and 49, 50. Another item is 17.
All right. Fresh notice to the opposite parties returnable.
At 79.
24th August. The unutilized requisites be utilized for the said purpose. Otherwise, fresh requisites shall be filed for effecting service. All right.
45, 46, 47, 48, 49, and 50.
And 79.
79. Item number 51.
51, I pray for some time, my lord. It's a challenge to a virus of section 14(1)(h) of the Lokpal Act, by which they are making it deemed publics. So I pray some time. I'll file with a written note and other judgments.
No, how are you affected here?
But I am one of the persons who have been engaged in such institutions as a director, an honorary director, and thereby I am required to now declare all my assets and in the name of my name, spouse name, my children's name.
What is wrong with that, sir?
That A to G is one class, or the class have reason nexus, but H is completely different.
Let's see that clause. You've set it out?
Yes, my lord. Lordship, can you have that? I have annexed the
41, page 41.
Yes, my lord. Any person who is or has been director, manager, secretary, or other officer of every other society or association, persons or trust, whether registered under any law for the timing in force or not, in receipt of any donation from foreign sources under FCRI in excess of 10 lakhs. Well, the institution is not been treated as a public authority, only the persons have been treated as a public servant. And all A to G are persons are directly either holding, receiving finance or directly in the discharging public functions.
No, but even G is any person.
No matter G is any person or as a director, manager, secretary, or other every society or association or trust or any law for the timing in force, whether or not, wholly or partly financed by government. All other, my lord, A to G, all other has a that kind of thing. It's only H.
But H is FCRI.
H is FCRI. Now, FCRI, my lords, there are several situations in which they are receiving. Individual is receiving, they are out. If the corporate is receiving, they are out. I have given it in my petition, my lord.
Who's for the opposite party?
It's central.
I am appealing, my lord.
It's manifest arbitrariness, my lord.
Who's appearing, sir? You're appearing. You're ready with the matter?
No, my lord, sometime.
You're not even carrying the paper book.
Well, let it come next week, my lord. Tomorrow, my lord.
All right. Counsel for the Union of India is not ready. Proceed in the matter. Mr. Ratha states that he'll prepare a note of submissions and file it before the next date. Tenth August.
10th
August. Item 52.
May I please, Your Lordship. My lord, in the item 52 and 53, my lord, Justice Raman.
All right. Please for a bench, which Justice Raman is not a member. On 21st April.
Item 54.
May I please, Your Lordship. You know, this is a case, a classic case of arbitrariness of state government authorities. Your Lordship might see.
Yes, please.
Yes. Your Lordship may kindly have a glance to Annexure 4. That is an agreement. And by this agreement, a road money was sanctioned by the government under PMI scheme for a construction road. 2 crore 77 lakhs was sanctioned by the government for construction of a road from Sadha to Padarukha under Kansas district had to be reblocked. Because that money has been diverted and utilized for construction of a road at different site, encroaching my land, as a result of which I am affected, I am deprived of my land. And my representation to open number 2 and 3 were not looked into. I was constrained to approach the Lordship. And in this, an interim order was passed. That it is there not to make construction over my land. And to the pendence of the case, they have filed a counter. I have reasoned that too. I will take a Lordship to one paragraph of their counter that will convince the Lordship. Paragraph 7 of their counter. Page 3. Miller, in reply to affirmations made in para 8 and 9 of the writ petition, it submitted that the construction in question is not a good new road. Rather, the existing road is being improved only. It is nothing but the construction and maintenance of improved and improvement of rural roads under PM GSY for which the cost of acquisition of land and payment of compensation to a person does not arise. Because they are important. After receipt of representation dated 19/1/2018 of the petitioner, the OP number 3 by its letter to so and so request the Taldar Hatadi for demarcation of the government land over which the road has been constructed. But the report of the Taldar Hatadi has not yet been received by the OP number 3 as stated Millard. But that report has not been received. That will clarify your lordship, because whether my lands have been enclosed or not, that report has not been received, and your lordship may call for that report, and opposite parties be directed to make demarcation, to make survey in the presence of this petition, so that things will be clear and my allegation can properly addressed.
Yes, Mr. Mohat.
Lord, so far as this case is concerned, what your lordship will find, since long status quo order is in operation.
That is different. No,
Yes.
no. In para
What I
7,
beg to submit, your lordship may kindly hear me for a moment. He is claiming that my private land is being encroached for the purpose of construction of the road. Our stand is that we are not making any construction of a new road. It is the existing road. We are only renovating. And he is saying that I should get the compensation. What I
no. He says OP number 3 is the collector.
Yes, OP number 3.
Collected asked the Tahsildar for demarcation.
That is what I am saying. If your lordship will entrust the collector, Keunjhar, to inquire about all these issues and hear the petitioner, and if any private land is actually encroached, and cause demarcation also through the concerned Tahsildar, and if the necessary steps will, if that private land is taken over or utilized for any road purpose, he will be entitled for compensation. So the collector may be directed to look into the matter and hear the petitioner and take into consideration all the documents which he will file before the collector. And I think the petitioner...
No, that will not make the things clear. My lord, they are thereby trying to conceal a bigger scam. Your lordship, the quantum of money is 2 crore 77 lakhs. That money was to be utilized at the place where the road was to be constructed as per the agreement. But they have totally diverted the entire money and made construction of a road where there are no roads. They have used government land for construction or improvement of road. They have made improvement of a ridge, and by imposing the private lands, that construction should not have been done. And all these government persons are involved in it. The money utilized for the purpose is not utilized. And thereby they have imposed private persons roads. We are affected. And our grievances to the collector and other authorities are not looked into. Therefore, we are constrained. So your demarcation report.
All right, sir. All right. The prayer of the present petitioner is that the grievance of the present petitioner is that lands belonging to them in Moza GP Sadha, Block Hatadi, District Keunjhar, is being utilized for the purposes of construction of a road without paying any compensation to them whatsoever. Further, it is stated that the construction itself is in violation of the specifications of site and place in terms of an agreement which governs such construction. Paragraph. Pursuant to the notice issued in the present petition. You say, while issuing notice in the present petition on May 2019, an interim order was passed that no construction of a road or otherwise should be raised over the plots in question belonging to the father of the petitioner. Paragraph. That interim order has continued since. Paragraph. In the counter affidavit filed by the collector, by the executive engineer,
OP number 3.
Bracket OP number 3. It stated in para 7, inter alia, that the collector, after receiving the representation dated 29 January 2018 of the petitioner, requested the Tahsildar, not the collector, that OP number 3, after receiving the representation, requested the Tahsildar Hatadi for demarcation of the government land over which the road has been constructed, open quotation. But the report of the Tahsildar Hatadi has not yet been received by the opposite party number 3, full stop unquote. Paragraph. Counsel the petitioner states that if the said report is called for, it will vindicate the stand of the petitioner that the petitioner's lands are being taken over for construction of the road. Paragraph. a direction is issued to the Tahsildar Hatadi to produce before this court along with an affidavit the report of the inquiry, report of the demarcation undertaken pursuant to the directions issued by opposite party number 3 by the letters dated 3rd May and 17th May 2018. Full stop. The said affidavit be filed at least 1 week prior to the next date, along with an advance copy to counsel to the petitioner. You say interim order to continue. List on 10th May.
And Lord, the Tahsildar may be implicated as a party. He has not implicated Tahsildar.
So, a copy of this order be sent to the Tahsildar Hatadi for compliance.
Item note 55.
My lord, the Honorable Court was asking me to inform the Honorable Court about the present status of the victim woman who got HIV infected after taking blood. I am filing an affidavit showing the present status, my lord. By God's grace, the victim woman is alive and she has married another HIV positive male.
Very good.
And the couple is staying in a place I have disclosed in the affidavit, my lord.
All right. Mr. Prabir Das has tendered an affidavit stating that the victim woman was contacted by him and it was ascertained that she had married another HIV positive male and the couple is staying in a village in Banarpal block in Angul district.
My lord, in this petition, 2 prayers were made. First, compensation for the victim woman because she got contacted HIV and she lost her newborn daughter due to AIDS. And second prayer was to ensure NAT PCR test. And I have come to know that this Honorable Court was kind enough to pass order in another case. For NAT PCR test. On that day, my lord was mentioning about this incident. I inquired.
When is it now listed, sir? 1st March.
Year 1st March.
Or list on 1st March 2023 along with writ petition civil 25727 of 2017. All right.
This matter will come on 1st March, my lord.
Along with that.
Item 56.
This matter relates to illegal operation of a railway siding operation without clearances and all inside a thickly populated area. On the last occasion, my lord has asked for a report from the collector.
That's last opportunity.
At the request of counsel to the state, last opportunity is granted to the collector. Sundargarh to comply with the order dated 22nd September 2022 on or before 1st March 2023 or say 3rd April 2023. List on 4th May.
Item 57. Item 57.
No, please discuss.
Item 57 would be infructuous.
Anyway, unless appeal.
Item number 58.
Memo taken on record. Dismissed is not passed.
I'm for respondent.
Item number 59.
For the respondent.
Item 59.
Unappears dismissed.
Item number 60.
There are two matters, my lord, where I have been, where I am some difficulties. Let it come some other day.
My lord, it may be adjourned to any other date because
My lord, what happened?
if
He has challenged the government's order because I am a on-shop license. This office being functioning since 1st July. That the year, excise year 2023 is going to be elapsed by 31st March. The objection he has filed after license is issued in my favor. In view of your lordship's judgment is there. Any objection filed after that stipulated time 15 days, that is not acceptable at all. And also 37 and 38, section 37 provides for preparation of shop for renewal, my lord. That process is on. He may file objection for 23 and 24.
Let it reach me.
if
counsel for the petitioner seeks a pass which is not convenient to counsel for,
My lord,
you are appearing for?
I am for OP number 5, licensing.
For OP number 5. List on.
And to short that.
17th April. No, 1 minute.
17th April.
No, sir. 18th April.
Obliged.
Item number 61.
61, my lord, needs some more time to file counter, my lord.
2014 matter, sir. You filed the counter, you didn't?
My lord?
You did not file the counter?
No, my lord, last occasion we took down, but could not be completed, my lord. Short date is
Last, at the request of counsel for the state, last opportunity to the department to file its counter affidavit on or before 3rd April 2023.
interim order to continue, my lord.
Interim order to continue.
Obliged, my lord. Obliged.
3rd May.
Item 62.
My lord, 62 is covered by case of automobiles. Your lordship said that reassessment will be made for the period from 1/2015 to 31/12/2016. This is to be
Give us
reassessed.
that order, no? With those changes.
Sorry, my lord,
No, kindly find out, give us the same order with those changes.
my lord, my lord.
Okay, let's post off.
Item 63.
My lord, similar order may be.
All right, Harish Majur.
Item 64. Item 64.
None appears dismissed.
May I please? Lordship, in the last occasion, the Lordship has been pleased to direct the opposite party counsel to take the instruction 29/11/2022 order to Lordship.
Yes, my lord, I have received the instruction. That is, my lord, if that is the deposit below 2,50,000, then my lord, that will not be taken into my lord assessment. That is the circular of CBDT. But here, my lord, case I have taken instruction. He has deposited 13 lakhs and some more total, which is more than 2,50,000. For that requires, my lord.
Where is your affidavit, sir?
Counter I have filed.
All right.
Yes, my lord. But here, my lord, I have only received the instruction I am submitting. I could not file the affidavit. That is the instruction with regard to your lordship's direction.
So monetary limit is 2,50,000. Yes.
Lordship, kindly have a glance at page 29 of the writ petition. Their order. Unexplained money is 1.6 lakhs.
Yeah, only 1.6 is unexplained, sir.
Total deposit.
Total-
That can't be the count.
Unexplained money.
That's the monetary limit. Yes. Even according to the department, as per the instruction issued by to the council for the department on 26 December 2022 is rupees 1.60000, whereas the rest of the amount of rupees 11,85,000 has been explained. The tax effect in terms of monetary value cannot be taken to be 13,545,000, but only rupees 1.60 lakhs, which is clearly below the monetary limit of 2.5 lakhs. Stop. In that view of the matter,
May remit back for consideration. By the revisional operator.
no, the assessment order under section annexure 5 and the consequential
Revision order.
revision order under section 264 of the Income Tax Act 1961, bracket annexure 9 are hereby quashed. The writ petition is disposed of in the above terms.
Lordship, already have deposited 20%. That may be
The
permitted.
amount deposited by the petitioner will be refunded in accordance with the rules not later than 12 weeks from today.
Item number 66.
My lords, I am appearing in item number 66 for the petition. Am I audible, my lords?
Yes, please.
Please. My lord, this is a writ petition which I have filed challenging the appellate order of the Additional Commissioner of GST.
All right.
Disposing of.
Yes, all right. This is the same first appeal. You paid 10%, sir?
My lord, this is a matter relating to refund, my lords. I'll just
Yes.
point out. I have filed the writ petition challenging the orders rejecting my refund of compensation cess, which I have paid, my lords, on one input, namely coal, which I have used for the manufacture of my final product, which is ferrochrome. I have, my lord, sold this quantity of ferrochrome domestically. I have paid appropriate tax, no dispute. I have exported this directly from my factory on payment of GST or under bond. I have claimed refund, no dispute. I have been sanctioned the refund. The law permits me, my lords, to clear the finished goods to an exporter as a penultimate sale.
The pleadings are complete now?
Yes, my lord. Pleadings are complete, my lords.
We'll set it down for final hearing, sir.
No prayer against us.
Sorry?
No prayer against us.
Yeah. That's all right. So pleadings are complete list for final hearing.
My lords, can it be on 19th of April? I am there physically for another matter, my lords. Because otherwise the matter can be disposed. It is covered by their own circulars in my favor. The appellate authority rejects a refund on a ground which is completely extraneous to the order in original it was passed, rejecting my refund. It can be otherwise taken up today itself. My learned friend is ready.
No, it's all right, sir. We'll take it up on 4th May.
Can it be on 19th April, my lord, please? If I am there actually physically for another matter. I have come from Bangalore. I am there for another matter. Therefore, I am requesting.
All right, you take a chance. 19th April, is it?
Yes, my lord.
All right, 19th April.
Obliged. Grateful, deeply obliged.
Item 67.
Item number 16, we are filing counter affidavit today.
All right.
I received the copy of counter numbers. We'll file rejoinder.
Rejoinder to be filed for the next date.
Interim orders to continue.
Interim order to continue list on. August 14th.
Item number 68.
Lordship, item 68 kindly pass over.
All right.
Item 69.
My lord, all these item number 68, all these matters, they seek refund. And in this refund matter, these are all old matter of 2015. Your Lordship may delegate the excise commissioner to examine their case, and if they are entitled for any refund, they will. And there is no need to keep it pending or.
In each of these petitions, the commissioner, the petitioners will file a application before the commissioner excise. Central excise?
No, state excise.
State excise, sorry. Commissioner said state excise. Commissioner excise. Government of Orissa. Not later than 3rd April 2023.
Seeking the relief sought for in the writ
Seeking the relief sought in the present petition. After hearing the petitioners on a date to be informed to them at least 10 days in advance, the commissioner will pass appropriate orders thereon. Not later than 10th July and communicate the orders to the petitioner within a week thereafter. If agreed by such orders, it will be open to the petitioners to seek appropriate remedies in accordance with law. The court clarifies it has not expressed any matter.
Item number 69.
Has it become infructuous?
Dismisses infructuous.
Item number 70.
I beg pardon, Your Lordship. This matter is infructuous.
Dismissed as infructuous.
Permitted to it.
Item 71.
Lord, item 71, Your Lordship has been pleased to pass order tagging this matter with some other matter to be listed on 28th of June 2023.
All right.
This matter is already tagged.
What is Chona?
28 June. Item 72.
72, my lord. I am appearing for the opposite party number 6, my lord. So I have just entered appearance. Your Lordship may give at least 1 week time to file counter affidavit, so it can be disposed of on the next day.
List on 28 June 2023, along with 28366 of 20.
My lord, I have filed a counter affidavit that may kindly be noted, and I have sought copy on the petition.
I filed rejoinder to that. Yesterday only the copy has been sought, my lord.
Yes.
Yesterday only the copy has been sought.
Yes. Yesterday.
No, which one is this?
72.
Asked it. Oh, 71, we've already passed the order. 72. All right. This is 72. You say counter has been rejoined to be filed before the next date.
One just request, man.
Interim order may kindly be extended, my lord.
All right. Interim order to continue list on 14th August.
Lord, I have just one small request, Lord. Government has already filed counter in my matter. Since the matters are all identical, let them adopt the counter in all other matters to cut short the litigation and an early date.
No, I will adopt. I will the same issue in.
All right.
Lord, interim orders in my matters to cut short.
Yes, I've said.
Obliged.
Item number 73.
73. Senior Attorney Roth is appearing. He is ill, my lord. I pray from next week, my lord.
Who's for the other side?
I am for the other
All right. Counsel for this, senior counsel for the petitioner state to be unwell. 21st August.
Item number 74.
Not
Item 74,
21st,
my lord.
22nd August. Sorry. Second.
Item 74. I am appearing for the assembly. I was requesting my learned friend if you could serve me an extra copy of the brief. They have not sent me the brief. I appeared today.
Notice said, I'll serve.
The appellant will serve a complete copy of the paper book on Mr. Subir Palit, senior counsel appearing for the respondent. List on 22nd August.
I may pardon, my lord. My lord, item 64, I am the petitioner, my lord, inadvertently, my lord. Your lordship, this was rejoinder and everything is ready, my lord, ready for hearing. Is my lord not able to, my lord, dismiss it, but I am the petitioner here, my lord.
All right.
My lord, say keep it next week, my lord. It's a bulky file, my lord. I have, because of all this list,
Right.
I'm not.
In 64, you say pleadings are complete. List for final hearing on 24th August.
Your lordship, please.
Item number 75.
Item 75. While getting ready in the matter, I found that one process is yet to be completed in respond number 3. So let me complete it by taking a fresh notice on respond number 3 with correct address. But she may take up the matter on a particular date.
Fresh notice to respond with 3 by speed post. Returnable on the next day. Tracking report will be placed to the top. Is there an interim order here?
There's an interim order.
Interim order to continue. 28th August.
28th August. 28th August, 28th.
Item 76.
So on behalf of Ms. Patnaik, no, she's well, not well balanced.
I see. Counsel for the appellate is to be unveiled.
76.
List on 29th August.
Also 78 minutes.
All right, same order in 78.
Item 77.
I received the counter. Please time to file the rejoinder.
Rejoinder will be filed before the next date. 29th August.
Item number 80.
80.
My lord, I am in VC, my lord.
My
My
lord,
lord, the record has been called for by my lord's order, last order. So the record has reached as per the note. So I need to have a verification to that records that has come. So kindly allow me 2 weeks time and thereafter.
Mr. Mahapatra and Senior Counsel, the petitioner seeks
LCR has come.
permission to inspect the LCR that has been received. The inspection be carried out in the chamber of the Registrar Judicial in his presence in the next 4 weeks on a mutual convenient date and time.
Right.
List on 29th August.
29th August.
Passed over. Supplementary list passed over matter. Item number 2.
12.
Item 2, sir. 2.
Sir, may I please your lordship? My lords, I'm challenging the revisional ex parte revision order, which I have filed against the annexure 1, which is the assessment order cum demand notice, imposing penalty under section 78(10) of the OVAT Act, 73(10) of the OVAT Act. My limited priority is, my lords, the revisional order.
Item 2.
Right. Yes.
May I submit, my
Yes,
lords?
please.
I'm filing this writ application against the revisional order passed under annexure 4 matters, being passed ex parte against the assessment cum demand order under annexure 1 series. My limited prayer matters, the revisional authority has passed an ex parte order without hearing me and without on merits matters. My limited prayer that may be restored.
Recall petition and that was also rejected.
My lords, I have filed a recall petition categorically praying that opportunity of personal hearing may be granted. That has not also been given, my lords. My limited prayer.
Appeal provision is there. He can appeal before the commissioner, my lord, under section 79(7). Additional commissioner has passed this order, so he can.
Let me go back, sir. The impugn order of the assistant commissioner was obviously passed in the absence of the ex parte in the absence of the present petitioner. Full stop. The recall petition has also been dismissed. Paragraph. With there being no dispute about the absence of the petitioner at the time that the impugn order was passed. On that short ground, the impugn order is hereby of the assistant commissioner.
And additional.
Dated
additional commissioner.
15th May 2019. And the order dated 13th August 2019 passed by the same authority, rejecting the petitioner's recall application, are hereby set aside. The revision case number 02/SA-1/MR/2017-18 is restored to the file of the Assistant Commissioner, CET and GST Territorial Range, Sambalpur.
Pardon, my lord, additional commissioner.
Additional commissioner.
Additional commissioner, not assistant commissioner. Additional commissioner. On 3rd April 2023, on which date the petitioner will appear along with a certified copy, the downloaded copy of this order. The additional commissioner will, after hearing the petitioner, pass a recent order afresh under section 264.
79(2) matters.
Under section 79(2) of the OVAT Act.
OVAT Act matters.
Within a further period of 4 months thereafter.
Obliged.
All right.
Past door matter, item number 10. Item 10. Item 10.
May I please?
Yes.
Here, the admitted position is not the assessment under section 150 was passed. If your lordship see assessment order, your lordship see running page 36. Lord. Because I've tracked on the assessment, otherwise, Lord, I will not able to. Your lordship see page 36. Please refer.
Lordship make see that same 35.
Let him.
No, I'm just, he skipped over one page of that assessment order.
No, it's all right. So let him argue in his own way.
Yes. My lord.
Millard in page 36.
Yes.
May I start, Millard, please. The unexplained cash credit loss plan. Please refer the assessment proceeding 153A/143(3) of the assessment 8-9. In this connection, we are requested to furnish the following informative explanation for completion of the shared assessment. From the record available, undersigned, it is seen that you have shown so-and-so with receipt from Calcutta so-and-so. However, having post such inquiry and survey under section 133A was conducted in the business premise of so-and-so to verify the genuineness of the such credit in your books. During the course of survey proceeding, no books of account of the company were found. Even no employee of the company was available there. Only Sri A.K. Chakravarti, an employee of A&R International, was present in the business premises. Though statement was recorded under oath, stating him about all these possible applications of the such finding, including treating the company so-and-so as baseless and paper company only. In this statement, Sri A.K. Chakravarti was categorically stated that only one company, A&R International Limited, is functioning from the said office premises and no other company concern is running. Function from the said office, even after careful rummaging from the premises 3rd floor, Draupadi mentioned so-and-so, no document relating to Ames Credit Capital Private Limited was found. The relevant person statement annexed herewith, and also the post-such proceeding, these findings were confronted to you. The relevant person was extracted below. Milord, these unexplained cash credit which has been shown, it was not been properly explained, no identification, nothing, Lord. Therefore, Milord, assessing authorities is compelled to, Milord, pass assessment order by applying section 68 of the Income Tax Act, where first appellate authorities confirm the assessment, and then tribunal, your lordship, see in the tribunal order, your lordship, start from, you will also place page 24, internal 6 of the tribunal order.
Yes.
Being aggrieved, paragraph 6.
Yes.
Being aggrieved, the assessing carried matter appeal, you have to file the following common retention Gannon become private limited, the present respondent, Lord. During the course of survey proceeding, no books of account of so-and-so were found, even no employee of the company was there. You let us keep all the, that was all these, the appeal order was reflected in this order. Now you will also see the page 28. The assessee pleaded that since the transaction received advance and sales sales took place as per the MU signed by two promoter groups, namely DDA groups and SKD group, copy of which was filed before the CLB and ROC. The transaction cannot be questioned from the point in view of identity and creditworthiness of the party so-and-so. The assessee perhaps intend to argue that since A&R International Limited belonged to DDA groups and as per MU, DDA groups has purchased share of Surya so-and-so from SKD group. It is the responsibility of DDA group to explain the source of advance given a purchase share, and SKD group cannot be asked to prove the genuineness of the amount. This is for sale of share. I do not agree with the view of the assessee. The onus squarely lie on the assessee to prove the identity and creditworthiness of the party, also genuineness of transaction. Lord, the whole argument of the revenue is, Lord, the respondent never proved this case by filing any credit ordinance of the company from which share has been allotted and the identification of the such companies, my lord.
But all this exercise has already gone into, sir.
No, my lord. Therefore, my lord, I am relying, my lord, three judgment. And this is judgment, my lord, the Calcutta High Court, Rajbandi Estate Private Limited. Said Supreme Court. I'm coming to Supreme Court. Please wait. Your Lordship, paragraph 23, my lord, is relevant. Start from page paragraph 20. Here the issue is, my lord, it is a money transferring, my lord, without giving any genuineness, and one after another shifting to one company to another, my lord. Therefore, this another could state, my lord, that it is only money lenders cannot be unnoticed because the assignment did not hold the required invoice except for calling of the records, my lord. Here, your lordship, see the paragraph page paragraph 21. We shall consider second question. In commentary of the Preventive Money Laundering Act, Mishi Mehthan published in Lexicon Nexus 21st step of money laundering, prescribable step of money laundering. I'm not guessing. Then your lordship see here, my lord, the honorable court held that only transferring the money without any, my lord, even though, my lord, is a bank transfer the amount, but no such company, no such, it is only a paper transfer, cannot be adjudicated.
So we are not on the merits. I don't know why you are arguing all this. We are only on whether there is material for, is it mere change of opinion or there is tangible material for reopening? That's all we are asking.
Only changing material is, my lord, he has not explained the.
That's not material, sir.
That is, my lord, that is in addition to the short note. That is a connected.
That's not the law, sir. That's not the law. You know the law.
Yes, your lordship. That's true, my lord. But and other than the two judgment, my lord, I am relying. My lord, Commission encounters P. Mahanakila and, my lord, the Kela Khan Muhammad Hanif's versus income tax. I have not quoted in the quoted in my appeal memo the issue of this judgment in running page 15, Lord. The gist of the judgment. The explained assessee offer no explanation means where the assessing officer no proper regional action explanation as regards some funds credited in the books maintained by the assessee. It is true. The opinion assessor for not acting explanation after the assessee as not satisfied is required to based on proper appreciation of material and other attending circumstances available on the record. The opinion of the assessor is required to be formed objectively with reference to material available on record. Application of mind in sign for non-forming the opinion. And second one is collect owners are proving the source of some money fund to have been received by the assessee on him. If he disputed liability tax, it is for him to show either that receipt was not income or that if it was exempt from tax under the provision of the act. In absence of such income, the assessor is entitled to treat as taxable income. Your Lordship is correct, Lord, so far as the 153, Lord, there is no matter, but so far as the addition is concerned, 68. Lord, my submission is, Lord, he has not properly established his case so far as the share application money, which is shifting one company to another company. And innocently proved that where from he is not shifting all these amounts. Lord. And I'm conscious of that, Lord, on earth and other things, Lord, was my senior is arguing, Lord, I am not questioning on that. It is true, Lord. But this is the only, Lord, revenue, so far as revenue is concerned, Lord, this is the only issue I want to place. Therefore, I request you, Lord, to keep it for today.
So, admit the following question is framed for consideration. Question B in page 16. This appeal by the revenue is directed against an order dated 19th April 2019, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT-80, in allowing IT bracket SSA number 39/CTK/2018, filed by the SSC for the assessment year 2008-09. Full stop. The original assessment, the big background facts are that the original assessment filed by the SSC was picked up for scrutiny, and for the AY in question, it was picked up for scrutiny, and an assessment order was passed.
Under section 153.
On when was that original assessment order, sir?
Annex 2 is the assessment order.
31. That's the present assessment order.
Yes.
And an assessment order was passed. Full stop. A search and seizure action under section 132 of the Income Tax Act 1961 bracket Act was conducted on 12th February 2013 in the case of Messrs. Ganesh Sponge Private Limited and group of cases where the respondent SSC, Messrs. Gangol Wincom Private Limited, is a group company. Full stop. Following this, notice under section 153 capital A of the Act was issued to the SSC on 6th May 2014. Full stop. The SSC filed a return pursuant thereto, declaring a total income of nil. Full stop. One of the issues confronted to the SSC was about unexplained cash credit received from a Calcutta-based company, which, according to the investigation wing of the department, was a bogus entity. Full stop. A detailed questionnaire was issued to the SSC on 18th February 2015. Full stop. The SSC furnished all the documents and bank statements and sought to explain the source of the credit as received through selling of shares full stop. However, the assessing officer bracket AO did not accept the explanation and made an addition of rupees 485,15,000 by the assessment order dated 31st March 2015.
Under section 68, my lord.
Yeah, under section 68 of the Act.
Yes.
Paragraph. The SSC then went in appeal before the Commission of Income Tax Appeals, bracket CITA, who by the impugned order dated, who by an order dated 26th March 2018 allowed the appeal. After noting that who dismissed the appeal of the SSC on the ground it had failed to prove the identity and creditworthiness of the aforementioned company and affirmed the addition made by the AO under section 68 of the Act, paragraph. Thereafter, the SSC went in appeal before the ITAT. Where inter alia it was contended
Para 11 is my contention.
Yeah.
Before the tribunal.
That the assessment under section 153 capital A of the Act had been made on the basis of the books of accounts of the SSC without reference to any search material found during the course of search. Stop. Relying on the decision of the High Court of Delhi in CIT versus Kabul Chawla, give it the citation. It was held that the addition cannot be sustained. It was submitted that the additions could not be sustained. Paragraph. The ITAT has in the impugned order referred to a number of decisions of the High Courts, including the aforementioned judgment of the including the judgments in principle CIT versus Meeta Gudkutia, 2017, 395 ITR 526 bracket Delhi. CIT versus Gurinder Singh Baba, 386 ITR 143 bracket Delhi. CIT versus IBC Knowledge Park Private Limited, 385 ITR 346 bracket Karnataka. And held that these were cases of unabated assessments and additions could be made under section 153 capital A of the Act only on the basis of incriminating materials found during the course of the search. Full stop. In the original returns, the SSC had duly disclosed the receipt of the advance in the regular books of account and claimed to have sold shares against the said advances in the immediately succeeding assessment year and had also paid capital gains tax on the gains derived on the sale of such shares. Full stop. The related long-term capital gains had also been accepted as genuine by the department in the assessment for the AY 2009-10 paragraph. The ITAT noted that the department was unable to point out any material unearthed during the course of search which would show that the advances in questions were not genuine. Full stop. Allowed the appeal on the above grounds. Paragraph. Before this court, Mr. T.K. Satpathy, learned senior standing counsel of the department, placed reliance on the decisions in Commissioner of Income Tax versus, Kale Khan Mohammad Hanif versus Commissioner of Income Tax, MA NU/SC/0292/1963, Commissioner of Income Tax versus P. Mohanakala, AIR 2007 SC 2116, and Rajbandir Estates Private Limited versus PCIT, Kolkata. Manu WB 03502016 to urge that the question framed by the court must be answered in favor of the department. Paragraph. Having perused the above decisions, the court finds that none of them deals with the situation of assessment pursuant to a search under section 130, assessment under section 153 capital A of the Act, pursuant to a search under section 132 of the Act,
was such,
and does not deal with the situation where no incriminating material is found in the course of the search, on the basis of which additions could be sustained, in the case of unabated assessments, under section 153 capital A of the Act. Full stop. In view of the settled legal position as explained in several decisions of high courts, which have been referred to herein before, as well as in the impugn order of the ITAT, the court is not persuaded that a different view should be taken in the matter as far as the present case is concerned. Paragraph. Consequently, the question framed is answered in the affirmative, that is in favor of the SSC and against the department.
only B, my lords. Only B.
Only B has been admitted.
Yes.
The
And
appeal is accordingly dismissed.
my lords, sorry for the interruption. The judgment my learned friend has cited, that one judgment, just for 2 minutes, I will take your lordship. Commissioner of Income Tax versus P. Mohanakala. There, my lords, the Honorable Supreme Court, Para 12, lordship may see, the learned solicitor has strenuously contended that the approach adopted by the High Court is totally erroneous. Full stop. The High Court in exercise of jurisdiction under section 260.
That's right. It's only on that.
Yes.
That's
Yes.
It. That's it. Well, that it could not have reappreciated evidence.
Yes.
Right.
Correct. But after Kabul Chala, I found another decision where your lordship's successor has highly praised the judgment, and that judgment I am giving, my lords. And as 2 judgments I am giving up, same, so 2 copies, my lords. And the bench has appreciated. And has lordship will lords, I'll just take your lordship to the paragraph. No. Sorry. Yes. Yes. This court.
That's it. 13, 14, 15. Paras
Yes. Sorry, my lord.
All right.
Okay. Just I brought it to your lordship's knowledge.
Yes. What used to happen is every time a new standing counsel will get up in Delhi High Court, and he will want to argue afresh. He'll say, no, my earlier counterpart did not argue these points. So we ended up, I was just telling you, we ended up repeating ourselves in a series of judgments.
After all, Delhi is Delhi.
No, we have the stamina to do all that.
For us, Delhi is too far.
No.
Like breeze too far. Much obliged, my
All
lord.
right.
Got a copy to.
All right.
Past door matter, item number 11.
Right.
Item 11.
My lord, 11, 12, and 13 are same arising out of my lord one order.
Yes.
8 days delay, my lord, due to the COVID-19.
All right. Delay will condone. Yes.
And my lord, the question is not 43B. And you lordship remember that in IFA case, your lordship allowed in favor of the department. And
electricity duty.
Yes. And one is allowed in favor of the association sales and lord NALCO. But the slight difference is not one is deposited in the bank, another is not deposited in the bank. Is taking lot.
No, but here, what is the position?
Lord, here that has not been. I'm not such blood I could find. And the another is not the second question that's is important, Millard. The adapted diminution value of 5%. Cost of these assessment 80% in the blood. There is a difference between taking cost of. Your lordship may issue notice in three cases, Lord. And
then notice on both delay and
yeah, your lordship. In three, all are three are same.
Notice on delay as well as the appeals returnable. 28 June.
Item 11, 12, and 13.
Yes.
All right.
Item number 16.
16 or 74 days delay, Lord. This COVID-19, Lord. And here, Lord, the whether the Lord running page 11, whether the factors and the line are justified to allowing claim of construction expense of Kendu leave go down, rupees assessment 13 treating a revenue expense or the capital issue. Your lordship judgment is there, lordship may issue notice.
All right, notice on both these, on delay as well as appeal.
Yes.
Returnable same date, 28 June. All right.
16 and 17.
Next one.
Item 18.
74 days delay, Lord.
No, that's okay. Anyway, notice will go if we are on this.
Yes.
Provision for pay revision. Is it not covered? I thought it's covered.
You know, see, issue notice of delay.
No. If it's covered, why should we issue notice?
But the provision is not, if there's provision is not subsequently paid.
All right.
You're not.
All right. Notice returnable 3rd July.
Much.
All right. In 18, you condone the delay. Then the SRS pointed out there's no delay. So the application is disposed of. All right.
Sorry for interpretation, my lord. Item number 62, I have supplied the similar order, my lord.
All right. All right. All right. With those details. All right.
18, 17, 18 both.
Weekly list. Item number 62.
Lord, may I just interrupt, Lord? I'm on virtual mode, Lord.
Yes,
your Lordship was, Lord, this is Aditya Das. Lordship was looking for me in the last hour yesterday regarding the Balarpur matter.
Only because Balarpur some matter was there.
Lord, it continues to be in NCLT, Lord.
That's what I think the council probably was not aware. So I'll tell him today.
Lord, item 7 of the weekly list, Lord.
Correct.
And Lord, may I seek one more small indulgence, Lord? I am in 136 on this list, Lord. Only prayer is not for this week because I'm a little indisposed due to ill health, Lord.
All right.
136, not for this week only. Let it continue on board.
All right, sir. All right.
I'm deeply obliged.
So item 7, you see.
Item 62, your lordship, just one Passover.
Pardon your lordship.
Passover.
My lord, item 62, your lordship. I'm in VC, your lordship, item 62.
62. No, 1 minute, sir. Just wait. We're just calling out item 7, sir.
Item 7.
My lord.
The court is informed by Mr. Aditya Das, appearing for the opposite party, that Balarpur Industries Limited is still before the NCLT in proceedings under the IBC, that is Insolvency Bankruptcy Code. In that view of the matter, the present petitioner is disposed of permitting the petitioner, the parties, to revive it depending on the outcome of the proceedings in the NCLT.
Right.
Lordship, item number 4.
4.
Yes, Your Lordship. I requested to be on the board, Your Lordship, but I have not been able to get myself.
All right, it will stay on board.
It remain on board.
All right.
I'll do it, Your Lordship.
All right.
Yes,
Item 62.
May it please your lordship.
Yes.
My lord. Item 62, your lordship, is an order that is passed by learned endowment commissioner, your lordship, which is on the face itself is not maintainable. My lord may kindly see, and we have purchased, your lordship, the father of the petitioner, Gandharva Mahanti, and his brother, Kartik Mahanti, Kartika Chandra Mahanti, they both have purchased a land way back by registered cell deed number 10155 by 59. My lord.
Yes, sir. Carry on.
My lord. The father of the petitioner, your lordship, late Gandharva Mahanti, and his brother, late Kartik Chandra Mahanti, they both have purchased a land by registered cell deed number 595, dated 59 and 10155 by 59. And since 59, we are in possession, constructing house and everything. Thereafter, your lordship, a proceeding in the year 2011 was instituted under section 25 of the Odisha Hindu Religious Endowment Act, saying that the property belongs to DT.
Yes.
My lord.
Who's for the commissioner?
Endowments.
Ms. Naidu is usually there.
Usually.
Ms. Naidu usually appears.
My lord.
But
the thing is that, your lordship, on the face of it.
No, I know, but somebody has to contest this petition.
That is true, but your lordship, since a person died on 3/1/91, he cannot be set ex parte by an order dated 26th September 2023. That is the whole case, your lordship. On 26th September 2023, the Honorable Commissioner Endowment says, opposite party number 1, Gandharva Mahanti, my father is dead. My father is ex parte because notice has been served on him. But the fact remains that as per Annexure 1, father of the petitioner is dead since 3/1/91.
All right. The case of the, all right. The present petition challenges an order dated.
That is Annexure 3.
1 minute, sir. 26 September 2013, passed by the Commissioner of Endowments in OA number 111 of 2011.
And so also its communication made to collector under Annexure 4.
Allowing an application filed by opposite party number 3. No, by Harihar Malia.
My lord.
He is what here?
He is, your lordship, he is a trustee. He is saying that he is a trustee.
Yeah, by opposite party number 3.
My lord.
Seeking eviction of the petitioners from the case land of the deity Sri Sri Kapileshwar Dev BJ at Kapileshwar PS Lingaraj District Khurda. PS Lingaraj, District Khurda under section 25 of the OHRE Act. Paragraph. It is apparent from the third unnumbered paragraph of the impugn order that the commissioner has noted that opposite party number 1 in the said OA number 111 of 2011, Sri Gandharva Mahanti, open quotation, has been set ex parte, unquote. The present petitioner is the son of late Sri Gandharva Mahanti. It is his assertion in the present petition that Sri Gandharva Mahanti died on 3rd January 1991. Full stop. His brother, late Kartika Mohanty, died on 22nd September 2013. Full stop. The death certificate of Sri Gandharva Mohanty has been enclosed with the present petition as Annexure 1. Full stop. Paragraph. In effect, therefore, the contention is that on the long before even the application OA number 111 of 2011 was filed, that is more than 20 years prior thereto, Sri Gandharva Mohanty, who had been impleaded as OPV number 1 in the said application, had already died. And yet his LRs, which included the present petitioner, were not impleaded as parties. Full stop. The submission is that the impugned order has therefore been passed against a dead person. Full stop. Paragraph. Although notice was issued in the present petition on 10th April 2014, and on that date, an interim order was passed staying the impugned order of the commissioner, till date, despite service, no counter affidavit has been filed by any of the opposite parties. Full stop. By a separate affidavit dated 5th July 2018, the petitioner has also filed the legal heir certificate, indicating all the legal heirs of late Sri Gandharva Mohanty. Paragraph. With the above facts being undisputed, the court finds the impugned order of the learned commissioner to be unsustainable in law, inasmuch as it appears to have been passed against a person who was dead long before even filing of the application in which it was passed. Full stop. On that short ground, the impugned order is hereby set aside. Full stop. The writ petition is allowed in the above terms. No orders is to cause.
My lord, the order was communicated under Annexure 4 to collector. It may be set aside also, your lordship. That may create some confusion.
All right. The consequential order of communication to the collector as a result of the impugned order is also hereby set aside. All right.
Obliged.
Item number 63.
Pardon your lordships. Your lordship, yesterday weekly list item number 52 was passed over.
All right. If you're ready, let's start.
Yes, your lordship.
Item 52.
Your lordships, my senior.
I'm sorry. I'm sorry, my learned associates made a submission that, but I am in a little bit of personal difficulty today. And apart from that, my learned associate has prepared a memo of citations to be handed over to your lordships. But if your lordship will just look at the award.
Yes.
Page 32.
Yes.
If your lordship will look at the last few lines of that page, the first party management has also not taken into consideration the award passed in so-and-so, in which 158 workmen with similar history of employment under the first party management were given temporary status and are still continuing in employment. This disparity in treatment, your lordship has it?
Yes, yes. Yes, please.
The contention of the petitioners before your lordships, before the labor court. Now, if your lordship, before the industrial tribunal, if your lordship will just turn over the page at page 34.
Yes.
34, last few lines. This is the contention of the management. The 158 workmen in TRID case are not continuing under the matter of microwave maintenance division. They have been deployed by contractors so and so as per contract with the first party management number 1 and are paid by the Oriental Securities. There is no employer-employee relationship between the first party management number 1 and the second party workmen, and also 158 workmen of the said IB case. This award was challenged before your lordship, and the single judge confirmed the award except for the part of regularization. And that judgment of my Lord Justice Mahapatra is not on record as far as the citation is concerned. This matter was carried to the Supreme Court. In the Supreme Court, it should work out the order of the single judge. Matter was subsequently the SLP has been dismissed. I wanted to place. And if your lordship that will grant me some time, because in any view of the matter, I'm in personal difficulty because I have a matter which is already started.
All right, we'll stay on board then. Stay on board. Right.
Yes, my lord.
Just give this back so that we can give it to us less time. Let's give this back. All right.
My lord, in this case, there are a batch of cases filed. The workmen have challenged the award and so also the management. Is your lordship keeping this matter in the board or to some other date?
It's on board.
Because my friend said that he is not in position to argue this case.
Today he's not.
Today.
Yes.
Item number 63. Item 63.
Sub-item I for the opposite party.
Yes.
Sub-item, my lord, WPC number 23. I am for the opposite party.
In 63, none appears for the petitioners. Dismiss for non-prosecution.
My name may be read.
S.C. Das for first item.
All right.
Item 64.
My lord, on behalf of Deepak Pani, pass over, my lord.
All right.
Item 65.
My lord, 65, I am for the opposite party bank. In this case, the auction was challenged. That auction has failed is recorded in your lordship's order 15319.
Right.
So, lordship, that has become infructuous.
The petitioner, in any event, the court is informed that the petition has become infructuous. So it is dismissed as such.
Item 66.
None appears dismissed.
Item 67.
And for the opposite party bank.
All right. None appears to the petition. Dismissed.
Item number 68.
Challenging notice under section 13(2). So I realize, my lord, what I am trying to tell your lordship is, my lord, lordship may dispose of the matter with a liberty. I'll approach the bank, not under OTS, because they say that OTS is not there.
All right.
I'll normally approach the bank to.
Or counsel the petitioner seeks leave to withdraw the present petition with liberty to approach the bank.
My lord, I may be excused. OTS proposal was not approved by the reserve.
I'm not asking. He's not asking for OTS. For appropriate relief in accordance with law. Disposed of is withdrawn with liberty as prayed for.
Right. But your lordship only indicate I have deposited 10 lakhs against 12 lakhs loan. I've already deposited.
But that's already with them. It's all right.
Wiki list item 69.
None appears dismissed.
Item number 70.
None appears to the petition dismissed.
Look, item 69.
You are for the opposite party. You are for the opposite party.
Yes.
We'll note down.
Wiki list item 71.
None appears dismissed.
Weekly list item 72.
None appears to the petition dismissed.
Item number 73.
Same order.
Item number 74.
Memo taken on record. Dismissed is not pressed.
Item number 75.
May I please, your lordship?
Yes.
Lord, this is against the impugned order passed by the Honorable Wakaf Tribunal, Kotak, where the evidence has been laid by both the sides, plaintiff and also the defendants. The documents were exhibited and the LCR if has come. I will draw my lord's kind attention to Exhibit 5, which is the turning point. Exhibit 5 is denied to be a gazette copy because it does not bear any gazette number, nothing. And that document, may Lord kindly have a glance if LCR is available, my Lord. My Lord, the fact remains the suit land is a embankment of municipal pond. The scenery that I have shown, I have also a sketch map added. At last page, kindly have a glance, my Lord. Page 66. At page 66, the sketch map of 1926-27 ROR map is there, which will show the pond and the disputed plot, subject plot, that is 451. Now, in subsequently, that plot has been divided into two parts. One in name of the government, that is in 86 ROR. That is in one part is in the name of the government, the other part is in the name of the municipality. Now, my Lord, kindly have a glance the ROR copy that is enclosed under Annexure 1 and 2. The Annexure 1 is the 1927 ROR and Annexure 2 and 3 are the 1986 ROR. Respectively, those are in the name of the government and also the municipality. Now, my Lord, this Annexure 1 was a Madhya Satyadhikari, intermediary land, which vested under in 1963 under Annexure 5, my Lord. That it vested free from all encumbrances under the Odisha Estate Abolition Act that I have also filed, my Lord. That is at Annexure. Kindly have a glance to that Annexure. That was marked Exhibit A by 1 by the government. Now, in the remark column, in the
Mr. Panda, who's appearing for the Waqf board? Have they been served?
Other side, 3-4 lawyers are appearing on one of Waqf board.
Appearing for the pocket take.
Point involved here in Miller.
1 minute, sir. Yes, Mr. Mishra, you are there.
I am there for the Fakir Tikia appear, that is opposite party number 2. For Waqf, I think Mr. Fayaz is appearing. Like in the other case, my friend was appearing in my case, which was item 1. I think because Madam Mira Ghosh is no more. She was previously appearing in Waqf matters. So I think Mr. Fayaz is appearing.
Inform him, sir. We'll put it on. It will stay on board. You just ask him to be there for tomorrow.
Your Lordship.
I also humbly say, at the time of hearing, the LCR will be required. My Lord will be pleased to call it for from the Kotak. It is the Waqf Tribunal Kotak.
One more thing I have to clarify.
Documents are there in the record.
May I just
evidence are there in the record.
With your Lordship's kind permission, may I just clarify one thing?
Also, there is no provision of appeal. It is only because of only High Court can interfere under section 83, subsection 9. Honorable Court can call for the record and examine it.
One thing I beg to clarify, my learned is referring to documents which are not part of exhibits. It can only be tested vis-a-vis what has been produced before the tribunal, not beyond that. And he has to come up with additional evidence if at all he is interested to bring those things to record.
Documents are exhibited in there by both the sides, by the plaintiff, also by the defendants. 3 sets of defendants were there, one government and municipality and also the Waqf board. And 3 said they all 3 have examined also their respective witnesses. They all exhibited the documents.
All right. You see, counsel for the petitioner states that the lower court record of the Waqf tribunal in WT/OA number 8 of 2013, in which the impugned order was passed, will be required, in which the impugned order dated 21st June 2014 was passed, will be necessary for a proper appreciation of the present petitions. Paragraph. Accordingly, a direction is issued to requisition the original case records of case number W.T bracket O bracket slash O dot A dash 08/2013 from the Waqf Tribunal Orissa, Cuttack. List in the regular list on July 10th. You say after the LCR is received, counsel for the parties will be informed by the registry to enable them to inspect the LCR and obtain necessary copies in accordance with the procedures, in accordance with rules.
Now, if your lordship indicates Mr. Fayez's name, he can appear also, my lord.
All right, the name of Mr. Fayez.
It
is there. Fayez Mohammed.
He is there. He is there.
It's already reflected, he says.
My lord, he is there. He is there, my lord.
All right.
What are you there?
Obliged. Obliged.
Item number 76.
You have to continue because imprimatur is there.
All nothing's going to happen.
Pardon your lordships. Pardon your lordships. Your lordships, item number 52. My learned senior was unable to pray before because of some technical error. So I prayed if this matter, item number 52 can be taken up on Monday.
Let's see. We'll do it.
Obliged.
Then memo is taken on record. Dismissed as withdrawn.
Item 77.
Right, please, lordships. Not the lease was granted on February 1 Suresh Sanjana. Thereafter, 1980, the RVR was published in his prepared in his name. Thereafter, I purchased the property in 2007. Well, your lordship, kindly see Annex 3, the impugned order. I do not know where from the Lord sub-collector has got the authority. So much appeal, page 20, my lord. Page 20. The sub-collector stating to be the exchange. 20, my lord.
So motor appeal.
So motor appeal. I don't know where, in which provision or which act he has got their power. Neither under Service Act nor under OGLS Act. He has exercised their power and also without him giving an opportunity. He said that he has issued notice, but we have stated in petition that we have not received any notice. The state has also not filed any counter to him.
You see, the challenge in the present petition is to an order dated 24th September 2013 passed by the additional sub-collector about town /PO Bhubaneswar, bracket opposite party number 2. In suo motu appeal case number 2415/2013. Directing to record the land of the petitioners in Hull plot number 6188 of an area of AC 1.000 decimal, Khata number 1716 in Moza, Andharua, PS Chandaka, Tehsil Bhubaneswar. As per the subject status, single quotes, Abad, Yogya, Anabadi, Khata. Unquote. Paragraph. While issuing notice in the present petition on 27th August 2014, this court directed status quo to be maintained in respect to the land in question. To stop that, stay order has continued since. Paragraph. Despite service of notice, none of the opposite parties, the opposite party state has not filed a counter affidavit till now. Paragraph 2. Mr. Manoj Mishra and senior counsel appearing for the petitioner submits that a bare perusal of the impugned order would reveal that the opposite party number 2 that is additional sub-collector, has exercised single quote suo motu unquote powers when no such powers exist in him under the Orissa Government Land Settlement Act 1962 (OGLS Act) or under any other provision in any other law. Full stop. Secondly, he submits that no notice was ever received by the petitioners in such proceedings, and therefore the impugned order was ex parte. Full stop. The petitioners state that they have purchased the property from the legal heirs of late Madhavananda Jaina, the original lessee, by way of a registered sale deed dated 15 March 2007, and have been in peaceful possession of the property ever since. Paragraph. With there being no counter affidavit to contradict any of the above arguments, the court proceeds on the basis that the impugned order passed by the additional sub-collector in purported exercise of single quotes suo motu unquote powers which do not exist under the OGLS Act, cannot be sustained in law. Full stop. Also, there is no denial of the assertion of the petitioner that the impugned order was passed without notice to the petitioners. Paragraph. On the above ground, the impugned order is hereby set aside. The writ petition allowed, no orders is to cross.
Item 78.
78, my lord, pass over.
All right.
Item 79.
None appears dismissed.
Item 80.
And for opposite party matter.
None appears to the petitioner dismissed.
Item number 81.
None appears for the petitioners dismissed.
Item number 82.
Same.
Item number 83.
83, my lord, that is covered by my lord's order. That is a suo motu power, assistant settlement officer, my lord, suo motu power, cancel the leave language.
Narottam Rata.
Yes, ma'am.
Same order. Yes.
Item number 84.
84 also same, my lord.
Same.
Item number 86.
None appears dismissed.
Item number 87.
None appears dismissed.
Item number 88.
Same order.
Week list 89.
Opposite party number 1.
All right. None appears for the petition. Dismissed.
Item number 90.
None appears dismissed.
91.
None appears to the petitioners. Dismissed.
Item number 92.
Same order.
Item number 93.
Same order.
Item number 94.
Memo taken on record. No instructions dismissed.
I find the memo.
Taken it on record, sir.
Item number 95.
None appears dismissed.
95, I am for the bank, my lord, it has already been settled, so it has become infructuous.
All right. None appears to the petitioner. Counsel to the bank states that the petition has been rendered infructuous, dismissed as such.
I'm sorry, my lord, item 90. I'm on
Yes.
PC for OP1, my lord. Item 90, loan account has been closed, my lord.
All right.
Restriction has become
90 also
infructuous.
same order. All right.
Oh, blessed.
Item number 96.
Item 96, madam, matter is in process.
Infructuous dismissed.
Item number 97.
May I please, Your Lordship? Because this is a matter under the Contract Labor, the Regulation and Abolition Act. Here the petitioners who have been working as security guards under the OPGC for more than 25 years under various contractors, labor contractor. Contractors are changed from time to time, but these persons, these security guards, they continue.
So item 97 pass over.
All right. He'll stay on boards. It's asking for a passover. All right.
Item 98.
So after lunch.
You don't know, sir, whenever it's called up. Right.
98 minutes, because of subsequent development, we have filed an affidavit that is at flag A. Lordship, in view of the paragraph 3 and 4, it has become infructuous.
All right. In view of paras 3 and 4 of the affidavit
At flag A, filed on 17/5/2018.
Dated 17/5/2018. The present petition has been rendered infructuous and is disposed of as such.
Obliged.
Item number 99.
None appears dismissed. Oh, memo is taken on record. Dismisses withdrawn.
Item number 100.
None appears dismissed.
Item 101.
None appears dismissed. Oh, memo taken on record. Dismisses withdrawn.
Item 102.
No instruction, Your
No
Lordship.
instructions dismissed.
Item 103.
103 reminded after launch.
Item 92.
Okay, 92 is memo taken on record. Dismissed.
Item 104.
None appears dismissed.
Item 105.
None appears dismissed.
Item 106.
None appears dismissed.
Item 107.
None appears dismissed.
Weekly list item 108.
Miller, on 108, I am on VC. This writ petition may be disposed of because the connected writ petition number 14324 of 2014 has been dismissed for non-appearance. In the same
And I
time,
am for the opposite party. That retreats on my learned senior is mentioning that has been dismissed for non-prosecution, my lord. I have filed an application for restoration just because my name has not been reflected in the cause list when the matter was listed, my lord. I have filed an CMAPL, my lord, for restoration of that application, my lord.
When have you filed it, sir?
then both the matters can be
Today I
taken
have
up
filed, my
together.
lord. I have the receipt, my lord, with me.
No, when did you file it?
Today I have filed, my lord. I have the receipt.
Today is filed. All right, let it stay on board. All right.
109.
On item 64, my lord, passed over matter. If my lord will permit, may I come?
We'll just finish through the list and then we'll call the person.
My lord.
Item 109.
None appears dismissed.
Item number 110.
110, my lord, pass over.
Item 111.
No instruction, my lord.
No instructions dismissed.
Item 112.
None appears dismissed.
Item 113.
Your lordship, I am appearing on behalf of Mr. S.B. Jana. Your lordship, kindly turn to Annexure 5, page 16. Your lordship, the pursuant to the Honorable High Court direction, the petitioner has made a representation, and after the making such representation, the amount which has been disbursed in favor of the petitioner, that is 1,54,346, but not the revised scale of pay. So I am praying to grant the revised scale of pay. The petitioner has already been retired.
Then what remains, sir? Nothing remains. The limited prayer, the present petition was that the revised scale of pay had to be paid to the petitioner by the opposite party. Number 2, no, the differential salary in terms of the revised scale of pay had to be paid by Opposite party number 2. In compliance with the earlier order passed by this court, by the learned single judge on 2nd September 2013, in writ petition civil 17303 of 2013. Paragraph. In the meanwhile, the petitioner having superannuated, the question of now payment of any revised pay scale will not arise. The petition is disposed of.
Item 114.
My lord, 114 and 115, I request for a pass over, my lord.
All right.
Item 116.
116. It's a small issue. The petitioner, in fact, was a borrower. But it was a checkered career. Earlier approached this honorable court, and during pendency of all these matters, the petitioner so moto repaid the bank loan without availing OTS. So since he repaid the entire amount under the so moto to the bank, he claims that he is entitled to certain benefit of 15%, something like that, and 4% possession charges collected from him. But without joining
representation, again, same thing.
Beg pardon, my lord.
He only says his representation should be considered.
Lord, yes, without joining issues over these disputed issues, Lordship may direct the bank to consider my grievance.
Right. The petitioner's representation, bracket Annexure 12 series, will be considered by the Chief Manager, some authorized officer, State Bank of India, Main Branch, Bhadrak. And after hearing the petitioners, a reasoned order should be passed not later than on a date to be informed to him 10 days in advance.
My lord, I'll submit a fresh application that will be fair enough, my lord.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to make a fresh representation to the opposite party bank not later than 3rd April 2023. It's so made after hearing the petitioner on a date to inform to him at least 10 days in advance. The chief manager of the bank will pass appropriate orders within a period of 3 months thereafter.
Yes.
And intimate the petitioner the order within a week of it being passed. The court clarifies it as not expressed anywhere in the matter.
My lordship, I am appearing for the opposite party bank on behalf of Mr. D.K. Mishra. My appearance may be noted.
All right. All right.
Next is same.
Item 117.
Same order.
Item 118.
None appears dismissed.
Item 119.
None appears dismissed.
Item 120.
Same order.
Item 121.
Same order.
122.
Same order.
123.
Same order.
Item 124.
Lordship, I am appearing on behalf of Mr. S.B. Jana. Your Lordship, the petitioner who was working as a peon. Working as a peon at Sesu. Your Lordship, the petitioner is no more, and the substitution petition has been made by the wife of the petitioner, and the petitioner who has been working as a peon but has been employed as a class 3 employee as Broadma operator, but has not been given any benefit of class 3 retirement benefit as a class 3 employee. Your Lordship, that's why I'm praying for the retirement benefit for class 3 employee.
Where is the substitution application? Is not there?
Your Lordship, IA number 759 of 2020.
Where is it?
That is in the
the evidence shows he never appointed as a class 3 employee.
But he has been employed as the
para 5 of the impugned order, award, whatever.
But Your Lordship, by the verbal instruction of the employer.
Please read, sir. Please read para 5. The petitioner challenges an order dated 2nd December 2014 passed by the Labor Court, Bhubaneswar, in industrial dispute miss case number 79 of 2012, which had been filed with the petitioner under section 33, capital C, bracket 2 of the Industrial Disputes Act 1947 for computation of the money due to him by the opposite party management. Paragraph. The petitioner's claim was that he had been working as a class 3 employee and had to be paid on that basis. Full stop. However, in para 5 of the impugned order, it is noted by the Labor Court as under reproduce para 5 paragraph. Counsel to the petitioner has been unable to persuade this court that the evidence brought on record by the petitioner before the Labor Court indicated anything to the contrary, and in particular showed that the petitioner was working as a class 3 employee as claimed. In that view of the matter, the court is not inclined to interfere with the impugned order. The petition is dismissed. Same 121 infructuous dismissed as such.
125. Item 125.
None appears dismissed.
Item 126.
My lord, I am for the opposite party, my lord.
None appears for the petitioner dismissed.
Weekly list item 127.
None appears dismissed.
Weekly list item 128.
Same order.
Weekly list item 129.
I am for the opposite party number 2, my lord, in this case, my lord.
All right, none appears to the petitioner.
Weekly list item 130.
None appears dismissed. We continue.
It can be disposed of in view of the settlement proposal approved by the asset reconstruction company.
All right. The memo is taken on record. The petition is disposed of in view of the settlement proposal approved by the Reliance Asset Reconstruction Company Limited, dated 4th August 2022.
Obliged.
My lord. The covered matter 98 cancellation after 24 years. But once this Honorable High Court directed to file a petition for rehearing. But the ADM once again 2014 once again confirmed the same. The lawsuit order is there.
Which item, sir?
Item.
Which item?
Item 103.
103.
After 24 years, it was cancelled under annexure 5, my lord.
Who's appearing for the government?
I am the purchaser, my lord. The petitioners are purchaser under annexure 552.
Which of who's appearing? You are appearing.
Yes, my lord.
Ah,
That's 100.
are you aware of this brief? You have the brief.
103.
100.
Item number 103.
103.
That is a disposed of, so that
What will we do?
stay on board.
Stay on board. We only stay on board. We have not disposed it of.
Okay, stay on.
Opposite party number
I'll
6.
just
But this order was challenged by the petitioner number 1, my lord. Now, this Honorable High Court directed to file a petition before ADM for rehearing the matter. Thereafter, he filed application under annexure 4, my lord, before the ADM.
Doesn't matter.
And other two petitioner number 2 and 3 who have already mutated, and they are also agreed by the self-same order. They have filed their application under annexure annexure 6, my lord, 6 series. But the annexure 8, page 59, your lordship, the ADM once again confirmed the earlier order. Even if the petitioner was found, the lessee was found landless and maintaining his livelihood on a daily wages basis. Your lordship, 59 paragraph, last paragraph.
1 minute, sir.
Yes,
You have the
sir.
paper book.
Yes, madam.
No, do you want to take
Page-
instructions or
Yes,
can we
madam.
allow it?
I'll take instruction.
You just give him a copy of the order, let him take instructions. It'll stay on board, sir.
Yes. Weekly list item number 131.
None appears dismissed.
Weekly list item number 132.
May I please the lordship? The petitioners were the shop owners of the MR Mata Puri Milers, and pursuant to order under Annexure 1, the petitioners vacated the shops for renovation of the MR Mata. And there was assurance in that order that after that they will be allotted shops. But the Mahant of the MR Mata did not allot them the shops and entered into an agreement with the private builder miners for construction of market complex. Now the present situation is that Matha has been demolished under the Sri Jagannath Temple Heritage Corridor minors. So my limited per minor, the collector may be directed to consider a case if a shop can.
No, but if it's already demolished, what can he consider?
Well, it's just some in some other place because Matha was to allotted. Matha is
You
not.
file a fresh representation.
Well, that we will do.
Counsel, the petitioner seeks leave to withdraw these petitions with liberty to file a fresh representation to the authorities for appropriate reliefs in accordance with law. Dispose of his withdrawn with liberty.
Item 133.
None appears dismissed. Both matters.
Item number 134.
None appears dismissed.
Look, I'm otherwise ready with the case. May I pray for 10 days time?
All right.
My voice box has
Yes,
been
yes.
impacted.
All right. All right.
There's a small application for amendment.
That's not there on board, I think.
1262 of 23.
Let's see where it is. Okay. I think just ask the junior to bring it on board. We'll anyway call it after 10 days.
Oblige.
Call it after 10 days. All right.
Item 135.
My 135, may I please, your lordship? I hear the against an award this case was filed. The question was whether he is a workman or not. Now, my lord, the party today says over phone that this company has been closed, taken over by some other. So it will be difficult to pursue. He says your lordship can dispose.
In view of subsequent developments, the present petition has been rendered infructuous and it is disposed of.
Okay.
Item 137. 137.
None appears dismissed.
Item 138.
138, my lord, since it is a 2015 matter, my lord, I have no instruction to whether that.
All right. No instructions dismissed.
Item 139.
None appears dismissed.
Item 140.
140, my lord, no instruction.
All right.
All right.
Item 141.
None appears dismissed.
Item 142.
Please, your lordship, I am on virtual mode, my lords.
Yes, please.
The petitioner has in the meantime expired. Your lordship has disposed of giving me liberty to move if any cause of action survives.
All right. It is stated that the petitioner has expired. Liberty is granted to the LRs of the petitioner to revive the to file a fresh petition if any cause of action arises.
Obliged, lords.
All right. The petition is disposed of.
Item 143.
143, my lord, I am on VC, my lord, I am appearing for the opposite party, OSFC.
All right. None appears, so the petitioner dismissed. Non possible.
Item 144.
My presence be noted, my lord.
Yes, please.
144.
None appears for the petitioner. Dismissed.
Item 145.
None appears for the petitioner. Dismissed.
Item 146.
May I please, Your Lordship? Lordship has disposed of identical matter, Your Lordship.
The preliminary issue.
Lordship, page number 32, annex of 10. I have specifically about that the issue regarding fairness of domestic inquiry may be decided as a preliminary issue.
All right.
But in this case, my lord, they have not completed the 17B, my lord.
17B for award. It is 33 to application.
They have not completed the 17B, my lord.
Oh.
You have to file an affidavit to that context. No affidavit has been filed till date, Your Lordship. It has to declare that we have not been gainfully employed in your Lordship. With a glance to section 17B of the ID Act.
No, was there an order for 17B?
Your Lordship. At the admission stage, that order was passed.
Then, Lordship, keep it next to Kalu in the meanwhile, I filed the affidavit, my lord. There is
Where was the order passed, sir? Which was the date of the order?
Your Lordship. Order dated 2nd of March 2017. No, in this case, no stay order has been passed. Since you have cavered, since you are identical two cases were disposed of.
No such orders there.
My Lord, senior was on cavered. In spite of that, they did not appear.
No such order.
No such order passing.
Same order.
Obliged.
Item 147.
Also, one small grievance. In this case, earlier for the Steel Authority of India, the appropriate government was state government. In the year 2012, it has been declared that the appropriate government is central government. So all the matter has been transferred to the CGIT cum Labour Code Bhubaneswar.
Oh, so it has to go to the CGIT cum Labour Code Bhubaneswar.
Industrial Tribunal Rourkela may be directed to transmit the record to the concerned.
The CGIT Rourkela. The Industrial Tribunal Rourkela will transfer the records to the CGIT Bhubaneswar. Right. Copy of the order be sent to both the Industrial Tribunal Rourkela as well as the CGIT Bhubaneswar. All right.
147, I am for opinion of 4, man.
Item 147.
None appears to the petitioner. Dismissal orders.
Item 148.
148, my lords, may I please? Well, the crux of the matter here is that we were allotted a plot of land right annexure 2, my lords, through a lease deed. But later on, my lords, the resumption case was filed and the land was taken from us for expansion of national highway. But as such, no expansion has been made and the land has now been illegally encroached by other people, my lords. So, my lords, I am pressing an IA today, IA number 18241 of 2018 for a direction to the opposite party collector to submit a status report as to the...
I'll take instruction. Okay, IA 18241 of 2008.
2018, my lords.
18, sorry. Counsel for the...
As a copy of the IA may be served on us.
The land which was supposed to be used for expansion of a road has not been so used and it is presently encroached by third parties. He seeks a status report from the collector Cuttack. Paragraph accordingly directions issued to the collector Cuttack to have the land inspected and to submit a survey report to this court as to its current status and the names and the occupants thereon. Within 4 weeks, list in the regular list on 12th April. The copy of the order be sent to the collector Cuttack forthwith.
Item 149.
My lord,
149 permitted to withdraw, my lord.
All right, dismisses withdraw.
Item 150.
My lord, in this case, the petitioner, who is a contractor, he submitted his wage bill to the opposite party for payment. And as it was kept pending, so he filed writ petition previously, which is under annexure 3, my lord. That was disposed of, directing the opposite party to decide the wage bill submitted by the petitioner under annexure 2, keeping in view the reported decision in Mahesh Prasad Mishra's case. But the opposite party has illegally rejected. Hence, the petitioner has once again filed this present writ petition. With your lordship's permission, I am reading the relevant part of these two reported decisions. The last line I am reading. In view of the aforesaid statement of law which has been declared by the Supreme Court and followed by division bench this court in Suryamani Naik and another division bench. The claim of the petitioner is covered by the decision of the division bench. Therefore, the same shall be applied to the fact situation and relief granted in view of clear pronouncement of the Supreme Court, which has been followed by this court in aforesaid cases. The stand taken in the statement of counter justifying impugn order cannot be accepted. Accordingly, the impugn orders rejecting petitioner's prayer for payment of price escalation, enhancement of rate of wages of labor and materials by Annexure 4 series are hereby quashed. And
where are you reading, sir? Which is that order? You're not showing us any order. Give us an order.
Decisions. And Nilagiri Engineering and one Mahesh Prasad Mishra.
Who's for the other side?
Lordship, the rejection order. Say money.
In Annexure 3, the previous order also at page 33, this Honorable Court has referred to these decisions. Page 33.
Page 28
at para 34. So my prayer, my case is covered by these two decisions.
Lordship, impugn order 5/11/2014. That this is the claim of 2006 and 7. And this is money claim. Lordship, the paragraph 2.
No.
Navaduga construction is a superclass and has given undertaking as well as furnished no claim certificate to the operating partner of executive engineer division balance that he will not claim any compensation on account from the due to delay in execution of the work. And he will not claim the benefit of price escalation during the period of mentioned in the work delay in completion. The delay was caused by him. And is not covered by that judgment that he is relying. And this is a completely money claim. Even if he has any grievance, he can go in the suit.
Now I don't know if he can, but anyway. This is not the remedy for that.
In this case, as the other side submitted, it is not 2007. There was a EOT, extension of time. And after completion of the work, that is under Annexure 2, he submitted the...
Who's going to examine all these facts, sir? These are all disputed questions.
The only they have by under Annexure 4, the impugn order is that when it is the stand under Annexure 4, I am reading that the rejection, the cause of rejection, that I am not entitled to get because the Mahesh Prasad Mishra's case is not applicable to me. The only legal point, whether I am entitled to reimbursement of the enhanced wage bill. During course of my work, there was several times there was enhancement of rate.
No, but you submitted a no claim certificate, sir.
My lord,
you submitted a no claim certificate.
No claim. As regards no claim, it is also clarified by the law department. That is in Annexure 6. I am reading the last paragraph. It is clarified what is no claim and how to which case it is to be applicable. Page 54. I am reading that para. It is not applicable to my case. I am reading. It is clarified by the law department. It was several times the contractors raised this question and it is clarified. But it is seen, last para I am reading, but it is seen in many cases that contractors are putting their claims for escalation in spite of no claim given by them earlier. It is to be decided if such claim of the contractors are consistent with the no claim certificate. At this point, Secretary Works Department observed that compensation and escalation are not one and the same. The object of payment of compensation is to make good the loss suffered by the contractor on account of negligence, default, and fraud committed by the other party. Does not cover escalation. Hence, no claim certificate would not be a bar to claim escalation. Members endorse the above view of the EIC Secretary. So here, escalation which was enhanced during course of my work. I am not claiming any compensation. I am just supposing today the labor rate is 100. Tomorrow it will be 120. I am bound, it is statutory payment. I am bound to pay 20 rupees extra. That 20 rupees I want to get back from the government. Only this much. Not 100. 100 I have paid. This enhancement of wage rate, which is enhanced during course of my time, that I have paid for reimbursement. And in these 2 cases, and it was went to the Honorable Supreme Court. Supreme Court dismissed the SL in Mahesh Prasad Mishra's case and in Nilagiri case. So their claim that as I have submitted no claim, so I am not entitled to escalation. So this is contrary to the two division bench decisions of this Honorable Court. So my humble prayer, I am to reimburse this extra payment which I have made during course. So that this is contrary to the Law Department order and also the division bench decision of the Honorable.
Is the second round of litigation concerning the petitioner's claim
my quantum, only that
for settlement of his bills pursuant to the execution of a contract for improvement to the Ranital Upari Sarisua Road in the district of Baleshwar under the NABARD assistance for the year 2006-07. Paragraph. Earlier, the petitioner had filed Petition Civil 16967 of 2014, which was disposed of with this court by an order dated 8 September 2014, requiring the opposite parties, Road and Buildings Division, to consider his representation and pass a reasoned order. Paragraph. Pursuant thereto, the impugned order dated 5th November 2014 has been issued by the Executive Engineer, Baleshwar R&B Division, rejecting the representation of the petitioner for being paid the enhanced labor wage bill. Paragraph. Counsel for the petitioner has relied on the decisions of this court in Mahesh Prasad Mishra v. State of Orissa 2012, Supplementary 1, OLR 1035, and Nilgiri Engineering Cooperative Society Limited v. State of Orissa 2011, Supplementary 2, OLR 683, to urge that the differential wages as a result of enhancement of the minimum wage rate is owed to the petitioner. And only to that extent, the present petition is being maintained. Paragraph. It is pointed out by Mr. Puntia Learned, AGF for the state, that the petitioner had in fact submitted a single quotes no claim certificate, unquote, to the opposite party number 4, stating that he would not claim any compensation on any account in the department due to the delay in execution of work, and that he will not claim the benefit of price escalation during the period mentioned for the work delay in completion. Paragraph. Whether in fact the petitioner would come up in the face of having furnished a no claim certificate, be entitled to the differential wages, entitled to the difference in the entitled to the enhanced labor charges, is a disputed question of fact. Full stop. Since it is being contested by the department, and the matter would involve leading of evidence by the parties, the court is of the view that the present writ petition is not the appropriate forum for testing the claims of the petitioner. Paragraph. The court is not persuaded that the above decision Mahesh Prasad Mishra was the State of Orissa Supra, or the decision Messrs. Nilgiri Engineering Cooperative Society Limited was the State of Orissa Supra would apply in the facts of the present case. Paragraph. Leaving it open to the petitioner to work out his remedies and other appropriate proceedings in accordance with law, the petition is disposed of.
Item 151.
The matter relates to OGLS Act, Your Lordship. I have purchased the land from my vendor in the 2004, and when the case is that the assistant settlement officer again resumes the lease. Your Lordship, before that, I have in 2004, Your Lordship, I have purchased from my vendor. The lease was granted in favor of my vendor. That was cancelled. Thereafter, my vendor approached to this honorable court. This honorable court has remanded the matter to the collector, land collector. Thereafter, the collector, after exercising his jurisdiction, has settled the lease in favor of my vendor. Thereafter, I have purchased the land from my vendor in the year 2004. And in 2013, Your Lordship, the assistant settlement officer also on the ranks of 5, again, Your Lordship, resumed the land. in exercise the IGP is 7. My lord's judgment, your lord's cover.
Narottam Rao. Same order.
51 and 52 both
This is the ASO's order, right?
ASO's order.
Mine. It's covered.
Yeah.
52 7.
Item 152.
Same, your lordship.
Same order.
Item 153.
And appeals dismissed.
Item 154.
Item 154, my lords. The conducting counsel has expired and I have instruction to appear, my lords.
All right. Counsel for the petitioner is stated to have expired.
My lords,
So
opposite
now on
party,
behalf of the
opposite party. My lords, opposite party. I'm for the opposite party bank,
Oh,
my lords.
you take that out.
I'm
It's an
sorry, I
appeals
should
for the
have been
petitioner
on that
dismissal
side.
non-prosecution. All right.
Item 155.
Memo taken on record. Dismissed as withdrawn.
Item 156.
156, my lord. I may be pardoned, my lord, I am in the VC. This is covered by the order passed in item number 14, my lord, of this very list. Day before yesterday, on Monday, my lord. But I could not get the order because it has not been uploaded, nor the certified copy has been supplied. So,
This is not correct. The order, this case is a different one than the other one. My lord, my peruse, my submission is they have challenged the action under section 13.2 and 13.4 in this writ petition. And according to the latest judgment of the Honorable
You have to go to the DRT.
no, my lord, not DRT, my lord, because the bank has been, the license of the bank has been cancelled.
Kindly see paragraph 2.
The license of the bank has been cancelled, my lord.
4 crores somewhat.
Your lordship may kindly come to, your lordship may kindly come to page 28, my lord. Sorry, my lord, page,
The remedy lies under section 17.
your lordship may kindly come to, because 17 also, no, it's not possible, my lord. Your lordship, page 34, my lord, the RBI, Reserve Bank of India order, my lord. At page 34, it starts.
Sir, you have to go under section 17, sir, of the
No, my lord, because the official liquidator has been appointed. Now the official liquidator has been appointed, the winding up proceeding, and the official liquidator has been in the last order.
Anyway, this writ petition is not maintainable then.
No, we'll go to the official liquidator, my lord.
All right. Counsel, the petitioner points out that the bank itself is under liquidation.
Yes.
And petitioners will approach the liquidator
Yes, my lord.
in accordance with law, disposed of as withdrawn with liberties paid for. All right.
Obliged, my lord. And the money that has been deposited, the official liquidator will take care of that, my lord.
Yeah, correct.
157.
None appears dismissed.
Item 158.
Same order.
Item 159.
My lord, here the petitioner, the purchaser, though their position has been noted down at the time of 7.3 proceeding, but they were never noticed. The order was passed. So this has to go back to the petitioner is a purchaser.
He has not been heard. So
All right.
I have not been able.
On the short ground that the impugned order of the ADM Bhubaneswar dated 8 November 2006 in lease revision case number 740 of 1987 was passed without notice to the present petitioner, who was the bona fide purchaser from the original lessee under registered sale deed dated
Registered is 83, my lord, 1983.
22nd February 1983.
22nd February
21
1983.
to
That is much prior to the passing of the impugned order, the said impugned order is accordingly set aside. And the said lease revision case is remanded to the file of the ADM Bhubaneswar, where it will be listed for directions. On 3rd April 2023, on that date, the petitioner will appear along with the downloaded copy of this order. The ADM is requested to proceed with the matter on merits, and after hearing the parties, pass a fresh order within a period of 4 months thereafter. Till such time, the interim order dated 21st January 2016 of this court will continue.
The second connected matter is also the same impugned order.
As same order that the connected matter.
But here we have appeared, but they have not considered our case. The same order in you are setting aside.
All right, then don't just say without
Let
notice.
it go.
See, the challenge in the present petition is to an order dated November 2006 of the ADM Bhubaneswar in lease revision case number 740 of 1987. Counsel, the petitioner states that the petitioner's submissions were not taken into account by the ADM when he passed the impugned order. Stop. This is not disputed by counsel of the opposite parties. In that view of the matter, the impugned order is set aside and lease revision case number. All others, same thing.
Item 160, obliged.
None appears dismissed.
Item number 161.
160 is cover matter of honorable court, ASO matter. Narottam Rath.
Narottam Rath.
Password matters.
I think we'll take the passwords.